This is a part-heard appeal in the matter of Johnstone and 3 sets of
My lords and my lady, good morning. I rise only for a moment at the outset to alert you, as my lady asked yesterday, Mr. Johnson, Alex Johnson, the claimant, is in court this morning. Simply to let you know.
Thank you very much.
Thank you. Yes, Mr. Platt, we were deep in H and D.
Yes, we were.
At least that's what my notes tell me.
Yes, and I will try and make it quick and simple and not trespass on your lordships and your ladyships' patience too long on this, but just to work to show you how Professor Jones has done his calculations.
Mm-hmm. All right, can I just say this, because I hold myself responsible. Don't feel that you've got to take it at a pace in order to finish by a certain time. The most important thing for all parties is that they say what they want to say.
Right.
Right, where were we?
So we were on 330B. Well, that's an invitation cancel would often jump at. 330B in the supplementary bundle. Lady.
333.
330B. Remember, those are the inserts.
Yeah.
Can I?
We were
I'm
looking
going to add further, because I thought yesterday when you were doing 330A and all the rest of it, that it must be in the additional documents which have been handed in. And I do not have in my supplementary bundle a 330A and a 330B.
on the first day of the appeal, my lady, they were handed up. I think put on the bench, put on respective.
Wait a minute, got it. Okay, right, thanks.
So those are obviously inserts. So 330A comes after 330 because the original bundle went hopping through the paper without actually running consecutively. So,
Fine.
and in fact, we've only extracted some of the pages and excluded most of the material relating to lung cancer and peritoneal. So perhaps I'd give your leadership just a chance to put that in. 330A was where we were, and then on to 330B.
Yeah.
Right.
And we looked at the end of the left-hand, the first paragraph on the left-hand side, where the authors say that the best fitting common slope is 0.75. That's what gives the value of R. R is the slope of the curve that's used for the extrapolation of the regression analysis. Then, Lord Lady, I'll try and take this as simply as possible, because certainly equations used to terrify me when I was at school. 330C shows you the equation that's used to work out the percentage increase. That is under the heading Development of Nonlinear Risk Estimates Mesothelioma, and then you see PM equals APL XR plus APR. That actually looks more terrifying than it is. The simple explanation is provided, in fact, in the joint statement of the occupational hygienists, and that's at page 215. Again, of the same bundle, where Professor Jones explains it. So
316.
215.
215.
215. So what Professor Jones does is, you can see in 3.8, he says he considers it helpful to clarify the nature of the extrapolation used by Hodgson Darton, ignoring peritoneal mesothelioma, the percentage excess mortality of pleural mesothelioma is represented as. So then he says, because he's taken out peritoneal mesothelioma, and you're left with just P equals A multiplied by X to the power of R. Now, so P is the percent excess mortality, so that's the figure that he plugs in to the table that's in the judgment, which is 0.022 eventually. A is the asbestos weighting dependent on fibre type, and that's a constant. So if one looks at Hodgson Darton, you'll see there's certain values given dependent on whether it's chrysotile, chrysotile or amazite. So A is a fixed figure that's been worked out from the various studies analysed, and X is the multiplier factor, which is the fibre mil years in the individual case, and R that you then take to the power of R. So that's the exercise he's done. Just to finish that off,
Just a moment, let me try and grasp that. So
Yes.
P is the excess mortality, percent excess mortality.
which is the one he's taken through to the judgment that you can see in that table that's on page 125 of the core bundle. It's page 59 of the paragraph 59. So if your lordships perhaps look at that as well, just so it all makes sense. The
Paragraph 59 of the
59.
judgment table we've looked at before. Yeah.
So if one looks at lifetime mortality risk per 100,000, best estimate, this is the figure that the trial judge worked to, is 0.022. That's the P figure.
So P is the answer you're looking for.
Yes.
And it's arrived at by applying the weighting for chrysotile, in this case,
Yes.
times X, which is the fibre mil years in
Yes.
the case. So the power of
So
R.
the power of R. So
And R is.
and so R is the shape of the curve. So when R was 1, it was linear, so it goes straight up. So when a power is less than 1, it becomes logarithmic, so it curves. And that's why the debate between the parties was whether it was linear or non-linear, because originally in Professor Norris' report, he looked at this and he said it was linear, but it's obviously not. Yeah. It's non-linear.
The critical issue then is the R, presumably.
It's one of the major issues.
Because if you assume it's 1, the answer is very straightforward.
Well, it's much more straightforward, but actually the way the authors have done it is they've made it more hazardous, as it were, more pessimistic at lower levels.
I understand that.
Yeah.
And then, can I just ask on paragraph 59, the table in the judgment, where do the figures for exposure for F mil years come from? Because they're not the same as those using method 1. And why is that?
I'm slightly struggling because that figure steer is taken from the fact that was ultimately the finding of the learned judge as to what Mr. Steer's measurement was and that it was preferred. I'm just looking that up. That figure, your lordship will find in the judgment at at the bottom of page 140, it's 103, paragraph 103, going over to 107 is perhaps better in the judgment, paragraph 107. So by applying Mr. Steer's calculations, the figure for EJ's exposure then becomes something in the region of 0.001 to 0.0025 million. And so in the table, the judge is Mr. Professor Jones's table. He's taken the higher exposure because he's made a conservative assumption here. So he's got 0.002.
So that's, I see where it comes from in the judgment.
That is different from the claimant's figure because what they took in their table was they took a midpoint, as I understand it, between 0.001 and 0.002, which is why they get 0.015. So it's just a different interpretation of that finding.
So, because if one goes to the table, I know it's in the appellant skeleton, but we've been showing this a lot, page 48, it's paragraph 69 of the appellant skeleton, which is where the actual dose is arrived at based on Raymond's dose, extrapolating down.
So I'm just it's on page 48 of the supplementary bundle.
Yeah. Yes. Oh no, it's the appellant skeleton, so it's
It's the core bundle.
core bundle.
The core bundle, I beg your lordship. Of course, so my bundle's now become detached. Yes, well, sorry, I'm with you.
So in the table, you've got the top half of that table is identifying the actual exposure, or the estimated actual exposure. And the ranges were 0.001 to 0.0015. And that's based on Mr. Steer's figure.
That's Mr. Steer's figure of 0.001 to 002, which is the finding of the judge.
I see. So, Mr. Chambers, we don't have Mr. Chambers' figures anywhere.
Well, we deal with estimate. I assume that figure is correct. That his estimate was of. I'm just trying to. Yes, that one. I think that figure is only they've taken in that one is only Mr. Steer's figure because it's not appealed. The finding of fact, the dose. I think if we look at the closing submissions of the claimant, I think we then get both those figures in it. So that would be in tab 3.
Because the table, is this right? The table at, on page 48 is assuming, subject to ground 5, that the figures for exposure are not in issue in the appeal.
I think that must be right. Yes.
Yeah.
Yes.
Right. And so I understand it now, on page 125, the judge has taken, sorry, Professor Jones? Professor Jones, I think he has done this, hasn't he? He's taken the highest of Mr. Steer's estimates.
Yes.
Yeah, thank you.
And then just to follow this through in terms of how we understand A's, if we go back to Hodgson and Darnton, I'm sorry to have to bundle hop in the supplementary bundle to 330 C, I think it is. 330, sorry, that's lung cancer, is 330D. So the top of the page 330D, the Lordship and the Ladyship will see there's a table, table 8, and if you look at best estimate slope at 0.75 for the R value, which is the one that has been applied, then you get a figure for chrysotile on in the next column, and at the head of that column it says APL, that's the A value, the pleural mesothelioma. So one looks at chrysotile, which is in bold at 0.0047. And that's then the A figure that Professor Jones has applied into his P equals A times X to the power of R. So we've now, that figure A is derived from studying the cohorts and working out the respective toxicity between chrysotile, and you can see chrysotolite is at 0.94, whereas chrysotile is much less. So they worked that out, and so you've got the R figure, which is the slope. You've then got the, as it were, the power of the toxicity, which is the A value. You know what your fibre mil years are, and you can work it out, and that's what he's done.
Sorry, I hope I'll bombard you with questions, but further one. In the Hodgson and Darton study, to what extent did they produce an extrapolation down to much, much lower levels? They refer to the possibility of that.
But that's what they do in Table 11. So I was going to come just before Table 11, just to mention that there's one other modifying factor in Table 9, which is on that page 33D, which is age. So again, the younger you are when you're exposed, the more likely you are to suffer from mesothelioma later. So you can see Table 9, you've got age at 35. Now, the deceased was 36 at the start in 1982. So in fact, she's less likely to suffer mesothelioma than if she'd been 25. But that figure is also used to calculate the risk. So the assessment at low exposure is then Table 11, which starts on 330G and goes over to 330H. So if we look first of all at the first page, 330G, your Lordships and Ladyship will see risk summaries for cumulative exposure between 10 and 105 mil years. So you'll see it chrysotolite at the very top. That's about 400 deaths per 100,000. So we're talking very serious risk of mesothelioma at that level. Chrysotile is still material 2 deaths per 100,000, but Crucidolite's obviously much, much greater. And then what the authors do is they work down, next one down is 1.5 mil a year, then 0.15 mil years, then 0.015 mil years, and then over to the bottom, the next page, 330H, risk summaries for cumulative exposures of 0.0055 mil years and lower. And we're obviously at 0.001, 0.002. And again, Crucidolite is still causing 10 deaths per 100,000. So even at the lowest levels, Crucidolite is still a danger to health. Amazite is best estimate 2 deaths per 100,000. Highest arguable risk 15, falling to less than 1. That's 0.407. So the authors here, they express the best estimate and then they put the band in. Then for chrysotile, it's simply insignificant. And that's at 0.005, but obviously we're a fifth of that, we're 0.001. So that is ultimately where the assessment can come on an objective sense. This is one of the reasons, my lords and lady, why we say that the third method is also of value, because you can make an absolute determination, looking at Hodgson and Darnton, that the risk is insignificant, rather than having to rely on a percentage calculation and the judge saying it's not significant. So this, we say, produces an absolute value of insignificance, and that's the approach that was taken in Bannister and to a lesser extent in Kerr.
But the point is, Hodgson and Darnton, the paper itself, which is a meta-analysis of all sorts of other studies, I understand it, they themselves did this extrapolation.
Yes. Yes. Oh, it's not a question of Professor Jones doing it. No, he's followed through the material he's been given by them, and they themselves are statisticians in the HSE. The only other point in Hodgson and Darnton that I would take your lordships to is on page 330F, where they comment on the methodology, because we've jumped ahead to table 11, not that mattered. They just give a commentary on it. That's on page 330F, it's the second paragraph down on the left-hand side. And what they say there is all the above implies that simply present a table of risk estimates or even risk ranges for different cumulative exposures cannot capture the changing balance of the different kinds of uncertainty. Table 11 gives a verbal assessment of risk at a range of representative cumulative exposures. No estimates have been given for a lifetime risks lower than 1 in 100,000, and this level is referred to as insignificant. A lifetime risk of 1 in 100,000 corresponds to an annual risk well below 1 in a million, which HSE has suggested in the 1999 publication as a guideline for the boundary between the broadly acceptable and tolerable regions of fatal risk to an individual. It's also well below the level at which it is suggested that mesothelioma would occur in the absence of asbestos exposure. The clear majority of the very few mesotheliomas that would occur at this level would not be caused by asbestos. So that's the qualitative judgment that they give on risks at that level. So once we have, as well, the Hodgson and Darnton material, then we get the calculation done by Professor Jones that we've seen in that table at paragraph 59 of the judgment. But we haven't finished there, because what Professor Jones has done is he's simply given us, on the basis of Hodgson and Darnton, the lifetime mortality risk per 100,000 at 0.022. He hasn't applied that to background risk yet. In fact, that figure is to be found in Dr. McGillen's evidence, which is at page 248 of the bundle. This calculation is probably the easiest way to show what's happened. So at page 248, the last three paragraphs on 248, Professor Jones has, as noted above, suggested a lifetime risk of 0.5 per 1,000 for the individuals who have only been exposed environmentally or who develop idiopathic mesothelioma. This is 50 per 100,000. So that's the Pito figure, which I will come back to, but it's 0.5 per 1,000. So that's your denominator on the calculation. So he says this is 50 per 100,000. Mr. Chambers' figure it gives an increase of 1.6. Then to the bottom line, Mr. Steers' figure adds 0.022 to this. That's the 50 per 100,000. That's an increase of 0.04%. So the Jones figure of 0.002, you then you divide by 50 and multiply by 100, essentially. So the 50 is the 50 in 100,000, you multiply by 100 to get the percentage. So that's how you get to 0.04%, which is where the judge gets his estimate of a risk less than 1%. So it's actually 0.04 of 1%. So that's the assessed risk using that methodology. So if, for the sake of argument, and I will come back to it, Lords, if I may, but the PITO figure of 0.5 was, say, 0.25. Say it's half, because if you recall, Professor Jones said it might be between 0.1 and 0.5. If you take the halfway figure, all you then do is you'd still apply Mr. Steers' figure of 0.22, but you divide by 25 and multiply by 100. So your figure would then be 0.08%, which is double the existing figure, but it's still tiny. So that was the answer to my Lord Justice Coulson's question to my friend, what's the difference on the 0.1 or the 0.5? And the answer is not much.
Well, but you need to test that properly. See what it would be at 0.1, don't you?
Well, 0.1 would be 1/5. You'd multiply by 5 then, essentially.
So the calculation, just so I've got this clear, the calculation that has been done is 0.002.
No, 0.022, which is the bottom one, which is that's the Jones figure.
Yes. Over 50.
Over 50, and then multiply by 100. You get your percentage.
And if it was 1%, it would be 0.022 over 10.
Yes, Lord. So if the figure was, if it was 0.1 in 100, 0.1 in 1,000, so therefore 10 in 100,000, you divide it by 10, and you essentially multiply by 5 the percentage risk of 0.04, so you get to 0.2%. That's the worst, as it were, figure on that band. Now, I'll explain in a minute what we say the judge did do, because he did apply 0.5 for good reason. But we're talking about...
Just so that I'm clear, on if you're taking it 0.1, the lowest of the range,
yes,
then you get to what percentage?
0.2%.
Yeah.
Because you simply multiply by 5 the figure that Dr. McGillen has worked out. And then, when, Lords, we're on this page, if we go over the page to 249, because this influences method 3, in the fourth paragraph, Dr. McGillen says, thus, doing the best I can, I advise the court that the absolute increase in risk by mesothelioma caused by Mrs. Johnston's work with the defendant is likely to have been medically insignificant when considering causation of the mesothelioma, both on the basis of Mr. Steers' estimates of exposure and the far higher estimates of Mr. Chambers. Percentage increase in risk above her background risk of developing mesothelioma in any case would have been medically insignificant on the basis of Mr. Steers' estimates of exposure. On Mr. Chambers' estimate, the increase above background would have been about 1.6%, whether or not such an increase, if Mr. Chambers' estimates were to be preferred by the court, constitutes a material increase for the court to determine.
So just to understand how these fit in, if you were wrong on the adverse inference point, and we were to take Mr. Chambers' figure, then the result would be 0.81 times 5 if we were to take the 0.1 figure from background risk.
My Lord, no, it would be 1.6 times 5.
Where's the 1.6?
That's Mr. Chambers. If you were taking Mr. Chambers' figure, are we?
Yes.
Yes, and then I'm saying if it's only 0.1, so therefore you take 0.81 divide by 10 and multiply by 100. I'm doing it in my head.
Yes.
You need to check that. But I think you multiply by 5 in the same way as you multiply by 5 on Mr. Steers' figure.
So 0.81 times 5.
0.81. Sorry, no, it's the increased percentage risk of 1.6. You multiply by 5.
Right.
So I'll stand to be corrected by those behind me as whether I've done my maths correctly, because I haven't thought about that calculation. But if logically the Mr. Steers figure moves from 0.04 times 5 to 0.2, Mr. Chambers' figure must move from 1.6 times 5 to, that would be about 9%. What I'm unclear about is that obviously Dr. Mogillan says that that figure of 0.04 is not a material increase. It's medically insignificant. It's not clear to me whether it's part of the appellant's case. It appears not to be, that they contest that. It appears to me that that is accepted, that if that finding is of the judge, therefore is robust, that they do accept that that is de minimis.
What point?
0.004, which
yes.
was which was the finding of the judge of less than 1%.
Right.
So certainly there's no appeal against that. So, and I would add that that opinion of Dr. Mogillan set out on page 249 of the supplementary bundle, that was never, he was never challenged on that. And where we were left, if one looks at the joint medical evidence, which is found, lady, on page 251. The attitude of Professor Twort for the claimants was found in paragraph 12, which is a rather unusual way of putting it. So, Your Lordship and Ladyship can see, he says, my estimate of medical risk will depend upon the finding of the court as to the cumulative occupational exposure sustained by Mrs. Johnstone and to the finding of the court as to her ambient exposure. So he essentially ducks it in that. Now, what's unfortunate is that there was some cross-examination of Professor Twort, where he said that he'd plugged his estimates into Hodgson and Darnton. He came out with a value of 1 in 10 million risk. That's not, unfortunately, in the supplementary bundle. But that's it for a friend's note. That's at day 5, page 57 of the transcript. So that's the only figure or estimate we had in evidence from Professor Twort. So when the judge says that the doctors aren't in dispute, that's correct in our submission, because either he gave no opinion in paragraph 12, or he gave an estimate of 1 in 10 million risk in oral evidence. Well, then just one more point to take on the, jumped ahead, in the Dr. Mogillan's evidence. In terms of looking at the the absolute risk, if one goes back to page 247, Your Lordships will see in the penultimate paragraph, Dr. Mogillan says, this risk, just to read above, he's looking at Mr. Chambers here, not at Mr. Steele. We'll deal with Mr. Steele in a minute. But he says, this risk, i.e. from Mr. Chambers' estimates, is below a lifetime risk of 1 in 100,000, would be described by Hodgson Darnton as insignificant. HSE considers risks in terms of risk per million, so 0.81, that's the Chambers percentage increase, per 100,000 becomes an 8.1 in a million lifetime risk. HSE also considers matters in terms of annual risks, not lifetime risks, and does so by dividing by a factor of 50. This is an annual risk of 0.0162 per million, i.e. an annual risk of just under 1 in 6.2 million. So that's on Mr. Chambers' evidence. And then he deals with what happens if we apply Mr. Steer, and that's on the top of page 19. And it's the last 3 lines in the first paragraph. He says there, I also, though, keep in mind that the estimate of risk arising from Mr. Steer's calculations as to exposure is around 40 times lower than Mr. Chambers. So if Mr. Chambers' risk was 6.21 and 6.2 million annual risk, as you can see from the previous page. The annual risk to the deceased was 1 in 248 million. That's right. Which is a minuscule. I mean, it's the risk is so small, it almost this has to be stated to realise that. So those are the levels of risk that we say talking about in this case, which is why Dr. McGillen was confident that if Mr. Steer's evidence was right, there certainly was no material increase in risk because he's just infinitesimally small.
One last question on this.
Yes.
We're looking at increase in risk as a percentage to find materiality. Mrs. Johnstone in this case had a lifetime risk of, let's take either figure, but let's take Mr. Steer's figure of 0.002.
That's a dose, Your Lordship.
Yes, dose. We're looking at the risk of developing mesothelioma from that dose.
Yes.
But that dose was less than, was it, the dose you'd find in everywhere?
Yes.
So this is a very simplistic question and therefore probably wrong. But if someone had remained in that position, never gone anywhere else, so that was their totality of their, I suppose you can't say that because there's idiopathic risk as well.
Yeah.
Why is it that we're looking at that as an increase in risk when it's actually less than the risk that otherwise is generally suffered?
Well, my Lord, there's obviously two ways. It depends. If you do method 2, you have to do this material increase in risk by depending against a baseline. Because you've got to define it by a denominator to work out the...
I understand how it works mathematically.
But method 3 does not require that. Method 3 simply works out what the likely risk is and has a doctor say that's not medically material. So you don't have to... One of the problems with dealing with percentages is when is de minimis not de minimis? Is it at 0.1? Is it at 1? Is it at 2? Mm-hmm. And it's rather like Western civilization, as Sir Kenneth Clarke said, you know it when you see it, you may not be able to define it. And sometimes it appears that exercise is the way it's done. But with method 3, at least, you can get a doctor to say, look, if that's not medically material. So it gives you, as it were, an objective inflow to the court to take a more fully informed assessment of that risk. Although what we say is that at 0.04%, 0.04%, that can be de minimis by a matter of intuition in the same way as it was in CARDA. There's obviously a huge issue which I'm reluctant to embark upon as to whether, if you can demonstrate that the idiopathic risk was the cause, you don't even get to Fairchild. And that's what happened in Kerr. So Fairchild says you've got to assume at the start that asbestos is the cause. So that's the what question, and then you deal with the who question, who should be liable. But if, for instance, mesothelioma is caused by also by radiotherapy, you have a debate initially, was it asbestos or was it radiotherapy? That's the what question. You don't even get to Fairchild unless you've got over that. But in this case, we haven't gone down that route. We've done it on the basis of the judge's findings of material increase in risk, and we then say method 3 as being, as it were, a gold-plated version of that.
But anyway, it's common ground that you do look at this by taking the figure for the risk arising from the actual exposure, or estimated risk from the actual exposure, and asking how much is that number a proportion of the general background risk.
Well, Lord, so it's not, when you work out that it's 1 in 248 million, you don't have a denominator there in terms of Peto. So that is just a straight risk based on Hodgson and Darnton, essentially, of saying that's the risk of mesothelioma. Yeah. So you don't have to look at that. What they say is at that level, it's much, much more likely it would have been caused idiopathically. So method 2 does require the denominator, does require Peto, so that's the baseline, as does method 1. Method 3 does not require that. Yeah. It requires just Hodgson and Darnton. So, I hope that's clear in terms of Hodgson and Darnton and the methodology. It's not straightforward. which is why method 3, we say, is almost an easier conceptual way of dealing with it. But given that Dr. McGillen's able to say it's a risk of 1 in 248 million, that's not material. That's a route 1, as it were, approach to take to this. Then, Lord, I've dealt with a lot of the points on grounds 1 and 4, but I have got some more to say about it.
So, what, on ground 1 and 4 now?
Yes, because essentially we say that they're two sides of the same coin. The extrapolation and the use of which model was preferred, because for model 2 to be used, you have to extrapolate from, or you have to use Hodgson and Darnton. What we say in terms of ground 1 is that, first of all, the judge accepted Professor Jones' evidence in preference to that of Professor Norrie, which is clear from reading the final 2 pages of the judgment. We say he took on board the caveats of Hodgson and Darnton, but that did not detract from his overall findings. And we say that the risks in this case were so tiny that they were accommodated by the wide margin of error that your lordships can see from those figures. And finally, we say the criticisms of Professor Jones are unmerited. He's a highly respected, time-served epidemiologist, in contrast to Professor Norrie, for whom this was his first foray into asbestos, and who's made numerous errors that litter the papers in this case. In terms of where that preference is stated by the judge for Professor Jones, that really all is contained in paragraphs 109 to 112 in the judgment. So it's quite clear, we say, what the judge wanted to do. So in 109, he sets out what Professor Norrie says, and rather by sidewind says this is his first foray, he says at the end of paragraph 109, into the world of asbestos-related disease, and that misunderstanding alone doesn't automatically undermine the value of the rest of his evidence. Professor Jones, on the other hand, was able to draw an extensive relevant experience applied to the factual matrix in this case, and use work models and tables to illustrate his opinion. Then the judge says, I accept the thrust of Professor Norrie's evidence, which I interpret to be the exercise of significant caution. I'll come back to that in a minute. We don't demur from that statement of the need for caution when looking at Hodgson and Darnton. But that's as far as he went with Professor Norrie's evidence. Then over the page to page 39, and the first line of that page, the judge records, in any event, Professor Jones did indeed, in my judgment, pay proper heed to the need for caution in addressing Hodgson and Darnton. In his report and in his oral evidence, he gave persuasive evidence about the formulations within the report, the range of calculations. And then jumping to 111, 6 lines into that, there's a sentence. On the other hand, comma, Professor Jones, in his evidence, demonstrated fairly compellingly why the level of EJ's exposure was such that she'd more likely be within one of the other remaining groups, ambient, unrecognised occupational exposure, idiopathic. And his observation was now seen in the context of serious calculation. Then finally, he says at 112, I find Professor Jones' insightful observations and opinions on the issues of lifetime risk, his work models, and his conclusions highly persuasive. So what we say is the combination of all these factors make quite clear that he's preferring Professor Jones's evidence, albeit that he's mentioned that Professor Norrie's evidence, but thrust of his evidence that you needed to have some caution when looking at Hodgson and Darnton was accepted, but that's accepted by the authors and by every other expert in this case.
I understand the point you're making, but I don't understand the last half of paragraph 111, because I thought the 3 groups were, go back over what we did yesterday, unrecognised occupational exposure, ambient in the environment anyway, and idiopathic.
Yeah, that's correct. I'm not sure he's looking at the original evidence of Dr. McGillen, which was that there were 2 buckets, but with one with a sub-cohort. So he had 2 buckets. One was unrecognised occupational exposure and also ambient exposure, and the other bucket was idiopathic. Sorry, he had two, but he said that the first bucket was then subdivided into unrecognised occupation exposure and ambient exposure. But I think that's probably what he meant, but I agree that it's not entirely felicitously phrased.
And that division is Dr. Morgillan's.
That was one of Dr. Morgillan's. I was just about to come to that to explain where Dr. Morgillan, where the judge got to accept that working of Professor Jones, because that follows on from paragraph 112. So what my friend did in his submissions was he said, he read paragraph 112 and said, I found Professor Jones' insightful observations and opinions on the issues of the lifetime risk, his work models and conclusions highly persuasive. And he says, but that doesn't explain, because Professor Jones varied in his evidence to a band of between 0.1 and 0.5 on Peter 1000, how he still managed to adhere to method 2. The answer is, if one reads on, what the judge says is that added to this was the evidence of Dr. Morgillan. The court does not reach conclusions in any case purely on the grounds of experts' qualifications or experience. But Dr. Morgillan's extensive recent involvement in mesothelioma research is a matter of which the court can properly take note in assessing the medical opinion that he expressed. And he says, moreover, having concluded that reliance should be placed on Mr. Steer's estimates, there was no material divergence of opinion between the two medical experts. I dealt with that last point, but in terms of Dr. Morgillan, essentially took a slightly different view than Professor Jones on this 0.1, 0.5 debate. And we can see that, first of all, by looking at the judgment. If we look at paragraph 68, what the judge records there is, when considering increased risk, Dr. Morgillan had looked beyond Hodgson and Darnton but not found anything that helped him in his assessment. In using H&D, he acknowledged the limitations and therefore took a best estimate, then looked at the figures in H&D, which considered each fibre type separately and did not just apply the ratio above. He's also familiar enough, he said, with PETO to apply the methodology. His interpretation of PETO was that there were 3 broad groups of women with mesothelioma. The first group with clear occupational exposure or live. I will come back to why that's a development. The first group with clear occupational exposure or live with someone directly exposed to asbestos. That left 62% in that group.
Not in that group.
That left not in that group, sorry. This percentage would then be split roughly in half, so this is where we get the 2 buckets, to represent first cases due to ambient exposure or unsuspected occupational exposure, and second, true idiopathic cases unrelated to asbestos exposure. According to P&R, those 2 second groups are represented by 1 in 1,000. Exactly where the line is drawn between these 2 groups is uncertain, but there's a substantial group who develop mesothelioma due to ambient exposure, which is represented by the 0.5 and 1,000. Though Professor Jones had thought that 0.5 was a bit too high, Dr. Morgillan wondered if he had fully understood the calculation in the way that he had presented it. Dr. Morgillan insisted he had not plugged in the information to the model identically. So Dr. Morgillan pushed back on that voluntary concession made by Dr. Jones in evidence and re-examination. And one can see where we get this from. We're looking at a number of references. So first of all, this page 231 of the supplementary bundle.
Sorry, your page?
231. And it's undoubtedly true that the use of thirds and halves is extremely frustrating when trying to understand what witnesses mean. So on page 231, this is general comments on the causation of mesothelioma from Dr. Morgillan. He says in the last paragraph there, in only about 1/3 of cases of mesothelioma in women is there clearly identifiable exposure to asbestos. Epidemiological evidence suggests, though, that in this country about a further third are due to such exposure which has gone unrecognised, or are cases in which the mesothelioma has arisen in consequence of background ambient exposure to which we're all subject. So there he's got 2 buckets, as it were. The risk from this latter form of exposure is extremely low, but many millions of people are thus exposed, and therefore cases will inevitably occur. This leaves about 1/3 of cases of mesothelioma in women which would probably have occurred even if asbestos had never been imported into this country. So what one is getting there, just to go back at the risk of repetition, his 1/3 there is 1/3 of the total. That's of the 100%. So if that's 1/3 of the total 100%, that is 1/2 of those two buckets, because it's 1/3 of the total, which of the 62%, it's 1/2, which is why I think we get into a number of confusions. So if you then add the half of the 62% is idiopathic, plus some for ambient risk, you get more than 0.5. And that will explain why the cross-examination goes in a minute. So
So just say that again. If you add...
So if one assumes that the 30% of all cases are idiopathic, that 30% is of the whole of the 100%, whereas we're looking at the 62%. So a 30% of 100% is actually 50% of the 60%. Does that make sense? So if you then add the element for ambient exposure, you're over 0.5.
Where's all this coming from?
This is coming from Pito.
Well, this isn't Peter, is it? This is Mr. Morgillan.
Well, this is Morgillan's. I mean, he's probably the most experienced mesothelioma physician in the country. So he obviously is, well, along with Dr. Rudd. Along with Dr. Rudd.
Yes, but so this is statistical evidence, though. This is about well, it's statistical evidence,
yeah,
which a doctor isn't. I mean, of course they can interpret it, but it's not. He's not giving evidence here about primary evidence.
No, he's interpreting Pito and such other knowledge that he's acquired in his life skills, and which aren't necessarily specified by him directly. So obviously the issue of idiopathic mesothelioma is clearly one that he knows about. But that's his interpretation of Pito, fundamentally. So where we then get to, if one looks at page 317, this is evidence in chief. You'll see that there's an exchange at B. So Mr. Williams says yes, and then Dr. Morgillan says, so let's take the risk of 1 in 1,000 from the two groups together. We have in there up to half, which may be truly idiopathic. So that's the 30% figure compared to 60%. We add to that up to half a substantial portion, which is likely due to ambient exposure, and then another group, one of unrecognized occupational exposure. Now, my interpretation of that, adding up to 1/2 of this group, adding to that substantial portion, my interpretation gets you to at least a half of 0.5 of 1,000, which is why in the joint statement I put, if the court finds that Professor Jones was correct, inaudible, 0.5 in 1,000, then the results is this. If the court were to find that, in fact, he had reduced it too far from 1,000, 1 in 1,000 to 0.5, which is my personal interpretation, the risk would be higher. So he's saying, I think it could be higher than 0.5. And where Mr. Swoboda took you to get the concession is, it really doesn't take us any further at all. That's on page 322. So that was the passage you were taken to, my lords and my lady, yesterday, where it was put by Mr. Swoboda to Dr. Morgillan at D that the idiopathic risk, according to Peter, was at most. And he essentially says, as a result, it's put to him that there's no lower boundary if it's at most. And he says, yes, that's right. I mean, that's clearly correct as a matter of definition, but it doesn't mean he resiled from his view that it could be 1/3. Just says he's correct, there is no lower boundary specified by Peter, but his view was, it was about 1/3. So he did not move, we would submit, from his initial view that it was over 0.5. Obviously, Professor Jones had said it's a range of 0.1 to 0.5, and the judge went for 0.5. So you had those options, and we submitted. That's a finding of fact, which is unobjectionable and was based on evidence as recorded by the judge. So we used Jones plus Dr. Morgan.
None of this is based on a study which has actually identified how many of them, in 1,000, do suffer from idiopathic or occupational, unrecognised or ambient.
Well, Peter is as close as you get because you interview the patients and ask them, were you exposed to asbestos? And they say no, and you then record them as not being exposed to asbestos. But it's obviously impossible to know whether it's ambient or idiopathic. Yeah. It's very difficult to know that because how does one check for that? So it's obviously the statisticians have done the best they can, and we have to use the best evidence we can.
Idiopathic, presumably, could be established ultimately because there'd be no presence of fibres, or is that too simplistic?
Ultimately, asbestos, when it's eventually completely eliminated from this country, yes, one could then do a control.
No, I mean in a particular person. If once they died, if there was no asbestos traces.
Well, my lord, that you can't do that, unfortunately, because crystal asbestos it's soluble and it's got a half-life of about 3 or 4 months inside the lung.
Right. So these are really just guesstimates.
I suppose if you had a control group that lived on Elon Musk took them off to Mars, and they all sat there, and you had a proper control group, you might be able to do it. Otherwise, you can't. The other point to take on Professor Norrie and his evidence was that actually, although my friend puts his criticism of Hodgson and Dart at a very high level, that's actually not what he said in evidence, which is why I would submit the judge was correct in his interpretation. So if we look very quickly at his evidence, it's page 281 first of all.
Sorry, this is, which point is this?
Sorry, this is
moved
supplementary
on.
bundle, I beg your lordship.
Have you just moved on from the 0.5?
I have. Sorry, Lord, I should have made that clear.
That's right. I like a heading.
Yes.
Every now and again.
Sorry. Yes, so those are my submissions to why what the judge did was he did, as it were, Jones plus Morgillon to get to Model 2.
Follow that.
Yeah. So then looking what Professor Norrie said about Hodgson and Darnton.
Oh, I see. Yeah. Okay.
That's supplementary bundle. I'll cut down the number of references just to, because I'm mindful of time. The best one is at the top of page 281, where he's being cross-examined by Mr. Williams, and Mr. Williams asked the short question, why?
So he being...
Sorry, Professor Norrie. Professor Norrie. And Mr. Williams says, why? And Professor Norrie says, as I say, at the time they took the data that was available and presented it in a meta-analysis that seems to me, first class. They have done what I have repeatedly said is a good and reputable treatment of all the data. They've explained the model that they have come up with, and to my mind, apart from the minor criticisms that I've just made, they have done a good job of representing the findings from that. So that, say, for example, myself, as a very experienced epidemiologist, could pick that paper up and get off to a good start with it. I understand what they have gone, I think done, I should probably say. I can go back to it on repeated occasions and qualify my understanding of it. So that, for me, is job done. But you ask the question, is it the best available? And it goes on to debate about the issue about whether it's best available. But he also comments further, go back to page 276. Where the section that I read to the court from table 11 is read to him, and Mr. Williams says to him, this is at B, so the authors are very mindful of the uncertainties, both statistical and otherwise, relating to this model, that they have produced an extrapolation down to lower doses, yes? And Professor Norrie says, yes. They discussed that carefully, but they nonetheless presented at table 11. He says yes to that. And then finally, on page 279, what he says at B is, so in answer to not in your experience, is again Professor Norrie being cross-examined. So there's nothing wrong with it. Do not get me wrong. They are faced with an extremely challenging task of getting across a very complex context with massive assumptions behind the scenes. And they are trying to do that in a table so that people such as me and you can come along and take what we need from it. But in the process of doing that, and with not having footnotes going on for hundreds of pages, they've used some terms that I mean, sitting here today looking at and thinking, well, I'm thinking, what does that mean? And then the question is, so do I gather from that, from what you've just said, that if you were peer reviewing this work of Hodgson and Darnton, you would not have approved it for publication? And he says, that's not what I said. I said if I was peer reviewing, it would be a point of feedback, which is obviously very different from this being presented as not worth considering at all. And then if one goes down to F, there's another yes from Mr. Williams, and the answer comes back, if there were thousands or hundreds of feedback points that the authors were just deliberately ignoring and not making any response to, yes, that would then constitute usually grounds for rejection of the paper. But this has, obviously, to my mind, gone through extensive peer review, and as I reiterate, it's a fine example of the Commission execution and analysis and publication of an epidemiological inquiry. So when we use the expression that Professor Norrie is mercurial, we respect that's what we mean. He seems to say different things at different times. And so given that approach, what we say is that the judge was right to accept the conclusions of Professor Jones that were to be found perhaps most conveniently in the joint statement at the top of page 218 of the supplementary bundle.
Sorry, page.
218. Just before we get to 217, at the top of 312, paragraph 312, the first five lines there deal with Professor Jones recognising the caution you need to deploy with Hodgson and Darnton. And he sets all that out in paragraph 312. And then over the page at 313, on page 218 of the bundle, he says, in summary, Professor Jones considers that the Hodgson and Darnton analysis provides the best guide that's available to the range of risks arising from a given low level of exposure to asbestos, and hopes that presenting results from it in the way in which he has done will be useful to the court in reaching conclusions in this matter. And I would submit that that is the conclusion that was then adopted by the learned judge in working through the model. And the final point that the Lady Justice Davies made, which we say is also important, is in the joint statement at page 214, at the end of paragraph 3.4. As your Ladyship noticed, it's the last 6 lines of that paragraph. It's Professor Norrie's opinion that using H&D 2000 model may lead to either an underestimation or overestimation of the risk of mesothelioma given the specified very low exposure. He is happy to clarify his position that if the decision had been taken that to use the H&D model for this purpose, extrapolating to risk at very low exposures, is appropriate, then what has been done by Professor Jones appears sensible and reproducible. So the only issue here is the principle of extrapolation. Nothing else in terms of everything that's been done by Professor Jones, it appears, is an issue with it. And the judge was then faced with the option of applying caution, but recognising this is a tiny risk and therefore supporting what Professor Jones had done, or throwing it all out and going for method 1, which is a clearly, we would submit for the reason we went through yesterday, an entirely inappropriate way of approaching matters. Well, then just to deal very briefly with a couple of other matters. Sorry, just before I leave this question of the right approach to Hodgson and Darnton, the Watch Committee was mentioned by my friend. Your Lordships will find that on page 336. Watch Committee stands for the Working Group on Action to Control Chemicals. It's at page 336, tab 27. And it's the last paragraph on that report that I draw the court's attention to, where the authors say Therefore, as recommended in the Watch position of 2008, because this was an updated final position of 2011, Watch considers that extrapolated risk estimates might be most useful as rough indicators of the magnitude of risk that might be involved in different situations. And that essentially is no different, we say, than...
Could you read on, David?
Sorry, yeah.
Read on for the purpose of the paper.
So, and hence the relative extent of concern and prompting towards risk management action that can be justified in different situations. Watch observes that deriving risk estimates by extrapolating the H&D model is a straightforward process. However, there is a variation of opinions across the committee, with no clear majority or consensus view as to the appropriateness of presenting such estimates in numerical form or using them for decision-making in a way that might be taken to apply confidence in their numerical accuracy. So what we say is that the cautionary approach of Watch was the one that was adhered to by all the witnesses called by the respondent, and that caution was reflected in what the judge said in his judgment, and he took a properly weighted view as to Hodgson and Darnton as a consequence. I have a section on competence, and Professor Jones, he's obviously appeared in front of the courts on a number of occasions. I don't know whether this, what I've pejoratively termed the credentialist argument, is one that you wanted me to approach, show where he's been praised by other judges for epidemiological work.
Is it contained in your skeleton argument?
Yes, it is. The main aspect to look at is just the Furnacite judgment of Mrs. Justice Swift, which goes to 330 pages. It's probably the most remarkable judgment in any industrial disease case in this country. She was a very fine disease judge, and she makes some very positive comments about his epidemiological ability.
She was a very fine judge, full stop.
And we were very sad to lose her.
We all were. I sometimes look round the Court of Appeal and wonder which one of us wouldn't be here if Mrs. Justice Swift hadn't retired early. I often think it's me. Do you want to just give us the references in the skeleton argument?
Sorry, Maud, I've got the references. I can give you the references in the bundle, but perhaps the references in the skeleton argument might be easier for your lordship.
Yeah, because you don't take us to it.
Yeah.
We just note down the references.
Sorry, I'm just looking for those behind just to find that for me. I'll come back to that. Furnacite itself is in the bundle, and the page from the 333-page judgment is extracted.
Right.
I would also say, because it's not in the judgment, Professor Jones is also the judge in Kerr, the Scottish case that's now in the bundle. He was the expert in Kerr, and also in Holmes and Purton as well. But the question that was asked by Lord Justice Zacaroli about competence and epidemiology, I just thought I'd make mention of Novartis, the decision. It's in our skeleton argument. I thought it might be useful to look very briefly at that. And Novartis is in bundle 2 at tab 24. Paragraph 58 of our skeleton, page 83 of the core bundle, my lord, is our references to Professor Jones.
Give me that again.
It's paragraph 58 on page 83 of the core bundle. So Novartis, my lord, tab 24. Novartis is a bladder cancer case, and I don't need to go into the facts of it, although it's obiter authority for the use of doubling the risk, if one's interested in that argument, paragraph 74, but just on this issue of competence of clinicians. Paragraph 52, first of all, on page 566. So Lady Justice Smith sets up the argument quite well, where she says, in November 2005, Professor Cartwright and Mr. Barnard provided a joint statement outlining the areas of agreement and disagreement. The main area of disagreement was that Mr. Barnard thought that the occupational exposure was significant and was the main contributor to the causation of the respondent's cancer. Professor Cartwright considered that the occupational exposure was so low that the exposure to amines in cigarette smoke must be regarded as a major contributor. On that basis, battle was joined at the trial. Mr. Barnard, the clinician, opposed to Professor Cartwright, the epidemiologist. And then over the page, page 5, 6, 7, top paragraph 55, the recorder said he preferred the evidence of Mr. Barnard to that of Professor Cartwright. Paragraph 56, Mr. Feeney submitted that the recorder ought not to prefer the evidence of Mr. Barnard. As an epidemiologist, Professor Cartwright was the real expert on these issues. Only he could have full appreciation of the comparative risks from smoking and occupational exposure as revealed in the published literature. The literature did not support the proposition that occupational exposure of the level revealed by the evidence increased the risk of bladder cancer. Mr. Barnard's opinion was that pure assertion, Mr. Barnard's opinion, he argues this, was pure assertion and went beyond his experience as a clinician. And then the conclusions of Lady Justice Smith at 57. I cannot accept Mr. Feeney's criticism of the recorder's reasons for accepting Mr. Barnard. The proposition that a clinician is not capable of fully understanding the published epidemiological literature on the causation of a condition within his own speciality seems unsustainable and would, I think, surprise many clinicians and epidemiologists. In my view, it was clear that from his detailed reports on causation, that Mr. Barnard was familiar with the published work. He was also able to discuss it intelligently when giving evidence. The recorder plainly was of that view. As for the suggestion that Mr. Barnard was too ready to assume that working for the appellant created an increased risk, this was a good jury point, that if it did not appeal to the recorder, that was an end to it. So what I'd say, certainly in disease work, experienced clinicians are fully entitled to debate the epidemiology. Particularly with someone like Professor Norrie, who's never done an asbestos case before, and through a large number of errors, had revealed his lack of competence.
But this is a debate between Professor Jones and Dr. What's his name? Sorry.
Dr. Morgillan.
Yeah. On this point.
Oh, no, correct.
And they're just interpreting what's in the PITO paper.
They are.
Or, yes.
They are.
Which,
And all I say is that obviously there's a hinterland of knowledge that Dr. Morgillan has that we're not privy to, that made him able to say what he did say. That's all I have to say on grounds 1 and 4. Ground 2 I've mostly covered in terms of PITO. There's only, I think, 2 points to make on ground 2. I've already made the point about the denominator in ground 1, method 1 being worse. It's just this schoolboy error I thought that I needed to draw the court's attention to, made by Professor Norrie, which is at page 197 when it came to PITO.
Page
Page 197
of the supplemental.
of the supplementary balance. Sorry, Morgan.
That's right. Yeah.
Perhaps it might be easier if I let your lordships read it to themselves. But what in essence is, I'll let your lordships perhaps read the first paragraph and then I'll read the second paragraph.
Sorry, David, 197?
It's 197. Yeah. So what Mr. Norrie, Professor Norrie has done in the last paragraph, he says, so given Mr. Johnson had radiologically proven mesothelioma and a death certificate giving mesothelioma as a cause of death, then if at most 1 in 3 mesotheliomas in females are not asbestos exposure related, idiopathic, then it follows here that 2 out of 3 must be asbestos related. Hence, on the balance of probabilities, Mrs. Johnson's mesothelioma and asbestos is asbestos exposure related, with the exposure from her work at Fawcett Garage in the absence of any other recorded or suspected asbestos exposure. Now, so that's kind of schoolboy approach to, was the red taxi, yellow taxi type approach to epidemiology, which is remarkable for someone who's supposed to be an experienced epidemiologist and clearly doesn't accord any of the evidence because it's ignored ambient exposure plus idiopathic exposure, which arguably would outweigh asbestos exposure. But, so that was another example of the way in which he took things. Well, I don't think I have anything more to say on ground 2, and I'm conscious of the time, so I'll move, if I may, to look at, before I look at ground 3, to very quickly look at Bannister. Lord, if I'm aiming to finish by 12:15, would that be?
Yeah, no, that's completely fine. I mean, as my lady said, please don't feel that we're truncating the time. I mean, I'm bound to say I had rather assumed that you might go close to or even at lunch, and then there could be a short reply thereafter.
I'm more than happy for that because there's quite a lot still to say.
Yeah, but that's fine. As my lady said, please don't feel that we're truncating your time.
Well, then, best way of introducing Bannister, which is the method 3 authority at this stage, is to look at our skeleton argument at page 76. Say 76. Sorry, I think it's paragraph 76. Let's see.
Page 76 is method 3.
It is, sorry, I'm looking at that.
Well, that's the heading.
No, I was looking at 86. So it's the proposition that was advanced in Bannister is in paragraph 32. And we say that this is a test which does import an element of mixed law and fact for these sorts of cases, where the deputy judge said, I've decided the test propounded by Dr. Rudd in Sloper and not resolved from in this case, which is agreed by Dr. Morgillan as a helpful and appropriate means of determining whether there's a material increase in risk. And that test was a dose of asbestos which was properly capable of being detected could be defined as a dose which a medical practitioner who's aware of the medical risks would define as something that the average patient should not worry about. That was if we look at Bannister, that was the test that was used there and applied. So Bannister itself is to be found in A19. Perhaps more, before we look at Bannister, I ought to just introduce the fact that this point was put to the learned judge. So if we look at page 132 of the supplementary bundle, you can see at paragraph 70, Mr. Williams, these are his closing submissions, sets out his position on method 3. And at paragraph 70, he says, D submits that what is material is likely to be an increase in risk which would not be disregarded as de minimis or viewed as immaterial by a medical professional. And then jumping to paragraph 75, over the page, he says, the approach of the defendants in Sienkiewicz differs from the arguments regarding de minimis that were advanced in Prescott, Bannister, and in the present case, the defendants failed in Sienkiewicz because they argued for an unsustainable test doubling the risk as the benchmark of what is material. And then if we go over the page to page 134 at C, the defendants did not call expert evidence that the risk was immaterial, this is in Sienkiewicz, e.g. medical evidence, but relied solely on epidemiology. It submitted that this is essential for an argument based on absolute risk to succeed. Medical evidence on positive causation of the claimant's doctor, Dr. Lawrence, that's in Sienkiewicz, was simply accepted. In this case, Dr. Moore-Gillen's evidence is that on the basis of epidemiological evidence and his clinical experience with asbestos, his view that this exposure risk was not significant or material. And then finally, at paragraph 95 in the closing submissions, That's on page 141. It says, by way of summary, initial summary, 95 paragraph 1, subparagraph 1, D contends that any assessment of whether C's occupational exposure to asbestos materially increased the risk of contracting mesothelioma should take account of the following matters: A, the level of occupational exposure and consequent risk; B, toxicity fibre type; C, the risk of mesothelioma from exposure to background levels; and D, the risk of spontaneous idiopathic mesothelioma. The analysis undertaken by D's experts, utilising the Hodgson and Darnton model and PITO case control study, takes proper account of these matters to enable a medical opinion on the medical significance of the deceased's occupational exposure. So that, you say, my Lord, set up the arguments in closing. We've already been to the conclusions of Dr. Morgillan, upon which he was not cross-examined, it was not challenged. And we've looked at the joint statement of the medical experts. So we say that the Bannister argument was properly set up and could have been adopted by the judge had he felt it appropriate to do so. And we say that if Your Lordship's not with us on method 2, that method 3 is a ready alternative to that. Bannister is in the first bundle of authorities, tab 9. It's quite a long lengthy text, which I'm going to jump through, hopefully very quickly. It involved exposure that was in a gentleman who was a manager at Freeman's, the magazine, which used to go into doorways, but now I think it's entirely online. And he said that when he was at work over a weekend, the builders had been in and they'd knocked down partition walls and they'd left asbestos in his office, and over the course of the week had been cleaned by cleaners, but that exposure was the cause of his mesothelioma. So we had a position, it was about a week's exposure declining, but it was also amazite, because it would have been asbestos insulating board if it had been any asbestos at all. And the ratio of the case is that basically the decision was that in fact he was wrong about that. There was not asbestos in the boards that were taken down, so the case failed on that. But the rest of the judgment is obiter in terms of the adoption of method 3, but nevertheless we submit is extremely useful nevertheless. The dose one can see by looking at paragraph 161, which is on page 217. Last paragraph there, paragraph 161, you'll see that the finding of the fact of the judge, assuming that there was exposure to asbestos, which of course he then found had not occurred, is 0.004 5 years, amazite. So that's a lower figure than in our current case, but it was amazite fibre, which obviously made it potentially more problematic. Now, the way in which he defined the test is on page 218, and that's the section that's been outlined in red. So your Lordship will see that paragraph 160 says, "I'm satisfied that causation cannot just be an issue of fact, but must, as Mr. Platt submitted, be one of mixed fact and law for the reasons he gave." Mr. Platt submitted further that the test was one agreed by both Dr. Rudd and Dr. Morgillan and Sloper. He then recites that and says at 168, "However, in cross-examination by Mr. Platt and Sloper, Dr. Rudd agreed that another reasonable formulation of such a test would be that a dose of asbestos which is probably capable of being neglected could be defined as a dose which a medical practitioner who's aware of the medical risks would define as something the average patient should not worry about." At 170, in cross-examination by Mr. Platt, in this case Dr. Rudd did not resile from such a formulation. So that was the formulation that the judge used, and he says that at 171, he's satisfied that that was the test to apply. He looked also, because the same arguments that we heard in this case with Professor Norrie where, although Professor Norrie was not called to give evidence in this case, they were made, again, about Hodgson and Darnton being too uncertain and shouldn't extrapolate, etc., etc. And those were made by Dr. Rudd as an experienced, very experienced clinician. But the judge rejected those arguments, and that's at page 223 at 185, paragraph 185. And he says that as to whether it's appropriate that I should rely on Hodgson and Darnton, I'm satisfied that it is the best and most appropriate paper available. Although any conclusions drawn from such paper cannot be definitive, it can offer a reliable but rough and ready indication of the degree of risk to which the deceased was exposed. Now, the risk itself, if we go over to page 224, at paragraph 189, that risk one can see expressed in paragraph 189, where the judge says, insofar as I suspect the reference to culpable was intended to be a reference to a material increase in risk, I do not accept Dr. Rudd's evidence. And I felt that he was straining logic and common sense to regard an annual risk of 1 in 50 million as a material increase in risk, and I am satisfied in making such an assertion that there was no material increase in risk. So he was looking at a risk of 1 in 50 million. Obviously, our case on Mr. Steer is 1 in 280 million annual risk. And in essence, he came to the same conclusion that, as I said, that we urge upon this court in the alternative in method 3. So we do say that the approach by the judge, I would say that because I was counsel it, but we do say that the approach was the correct one and that he's properly identified the issues and properly formulated a test that the courts should adopt.
So is that the only test the judge applied in that case?
Yes.
Would a doctor have thought it was something an average patient shouldn't worry about?
Yes, because the view was taken by myself that I didn't want to go down the relative risk argument because I didn't know what it was by using the denominator, but we would use the absolute risk, which was Hodgson and Darnton, 1 in 50 million, and then use a clinician's opinion as to whether that was a medical risk, because that had already been tried in Sloper, and in fact, in the end, the judge again didn't need to go that far because in Sloper, again, there was found to be no actual exposure. So that's why this line of authority is developed under method 3, because it provides a yardstick that the courts can operate easily. And if there's a disagreement between the two clinicians, then the court will decide on that. So if one says it's material and another says it's not, then you can decide on it.
So this isn't, these aren't methods defined anywhere else, but what you're calling method 3 is you start with the Hodgson and Darnton extrapolation.
Yes.
And when it gets so low that you can't use a denominator, is that right? Because it's
you don't need to, because a clinician can say, I wouldn't worry about that. From a medical perspective, that's just not a risk I would be concerned about. And there's no magic as to how one has to define de minimis.
But if you, by definition, if you've reached that lower level, it's always going to be immaterial if you then calculate that over a denominator.
Well, I suppose you could do, and work out a risk of 0.000% or something. You could do that way.
So is it really?
Well, it's only because it's trying to set up a different route or lane to take that avoid you having to look for a denominator and then argue interminably about what the denominator is. And so you can work out what the annual risk is or the lifetime risk, and an experienced clinician like Dr. Rudd or Dr. McGovern can say, I wouldn't worry about that. And that, we would submit, is appropriate for these sorts of cases. I mean, it won't work in every disease by any means, but appropriate for mesothelioma cases is a yardstick and a way in which to calibrate de minimis.
It's going to depend also on the quality of the medical expert.
Oh, entirely.
I mean, in Dr. Morgillan and Dr. Rudd, you have two clinicians, forgive the way I put it, who've been round the tracks. They know this area, they're experienced in this area, both as clinicians and as experts advising and giving evidence in cases. Not everyone has that expertise.
Maybe I'd absolutely accept that. And obviously, if Dr. X turns up to court and is cross-examined and it's clear he's not an expert in this area, then the judge entirely within his rights to reject that.
Yeah,
So
but then where does that leave the judge in respect of method 3?
Well, the defendants wouldn't be able to establish that it was de minimis, depending on what evidence was then put forward by the claimant. And the claimant hadn't advanced any evidence. That would leave a rather weird limbo, but assume he's put a positive case forward as to why there was a material increase. If the defendant turns up with an expert who doesn't come up to puff, then the claimant gets his judgment. So I think it's said by those on the other side that in some way one is outsourcing causation to doctors. I mean, you're not. It's simply allowing the doctors to put their opinion forward, and the court can accept it or reject it.
But you're still, even with that, you're still starting with Hodgson and Darn.
Yes. The other case to mention was where and again I'll do this very quickly, is Kerr, which is a Scottish case. It came out after the judgment and after skeleton arguments, in fact. It was only just reported at the end of last year. It came out just before Christmas, 20th of December. That's in tab 5 of bundle 1. So obviously a decision in Scotland is to do with a lady who was exposed from working with Bunsen burner heat mats, which are all chrysotile. And there were 2 defendants in this case. There is an important distinguishing feature to this case, which is this is peritoneal mesothelioma. And what is interesting is that it appears to be implicitly conceded by my friends that Hodgson and Darnton says that at lower exposures, there's no risk at all of peritoneal mesothelioma from low exposure to asbestos. To chrysotile. I've got the impression, and I'm sure I'll be corrected, that that's accepted by the appellants in this case. So the utility of Hodgson and Darnton is really not attacked when it comes to peritoneal mesothelioma, but only pleural mesothelioma. And I doubt if that's not accepted, then we'll see. But that certainly is a distinguishing feature because it's peritoneal mesothelioma, and the judge agreed, and even the clinicians find it difficult to argue that low levels of chrysotile exposure gave rise to peritoneal mesothelioma, which is a cancer of the stomach lining rather than the only sort of short points to make were that the dose is on page 51. Sorry, the dose is on page 49, I think. Sorry, say
48?
It's paragraph 49, I beg your lordship. Just trying to avoid and go through the argument. Yes.
Paragraph 49.
Paragraph 49 on page 66. Where the judge in the outer house, who's Lord Malcolm, said, given all the uncertainties, any attempt to estimate the airborne concentration level is no more than speculation on any view. Any cumulative exposure to respirable asbestos was small, perhaps as per Dr. Jones' estimate of 0.001. So it's a very small dose, again, indeed. Again, a similar sort of choreography to what occurred in Bannister with different players. Dr. Mogillan gave evidence, and so did Professor Jones. But at paragraph 69, the claimant's physician, or the pursuer's physician, I should say, attacked Hodgson and Darnton. So that's paragraph 64, which is pardon, on page 71. So Dr. Dempsey was their respiratory physician, and in the third line of paragraph 64, the judge records, in essence, Dr. Dempsey said that there was no known safe threshold and that all asbestos fibres are capable of causing cancer. Zero tolerance to any unnecessary risk. For example, touching asbestos is understandable, but the legal test of material risk does not allow the court to adopt it. As will become apparent, I do not share his criticism on reliance on the epidemiology. And then his findings are on paragraphs 72 to 74, which are highlighted in red. on the left-hand side. Just to jump through those, paragraph 73, Lord Malcolm says, the approach I'm taking is similar to that adopted by the Deputy Judge in Bannister. In Sienkiewicz, Lord Nichols of Birkenhead defended the potential role of epidemiological evidence given that matters are determined by proof on the balance of probabilities. And then jumping to 74, on the next page, paragraph 74, Lord Malcolm records the Hodgson-Darnton study is eloquent of the difficulty in establishing any link between predominantly chrystal exposure and the development of peritoneal mesothelioma, let alone at such a low dose, and I consider that the witnesses were well-founded in relying upon this material. There's no inconsistency with the evidence that the assumption is that there's no safe level. That's a wise precautionary approach for employers and others to adopt, but it does not follow that whatever the specific circumstances, any exposure to asbestos will lead to a material increase in risk in terms of the Fairchild exception. So, once again, it's a Bannister sort of case, peritoneal mesothelioma. The only addition, though, if one goes to page 76 in paragraph 77, is that the argument which I'm nervous and don't intend to go into, which is, does Fairchild apply at all? So if you have to ask the what question, first of all, is it asbestos or is it something else? Is it idiopathic? Before you get to Fairchild material increase in risk. Now, clearly, in this case, we've accepted that it's material increase in risk, but that argument is one that is bound to occur at some stage in the higher courts in this country. But he's proffered that view, and I don't think it's right to go there this morning.
It's not a method 3 case then?
Well, it is a method 3 case because he accepted Dr. Morgillen's view that this was not material risk and it was de minimis, and he used Hodgson and Darnton. What I meant by the argument at the end about Fairchild.
No, I understand that.
Yeah.
I'm going back to.
Sorry.
I must have missed where he.
I'll just see if I can find where I think it's paragraph. Find where. Yes, it's paragraph 37, which is on page 61. So what Lord Malcolm records there is, if the Hodgson and Darnton study is correct, and it seems reliable, there is no demonstrable risk of peritoneal mesothelioma at occupational levels of chrystal exposure. Chrystal is much less carcinogenic. In his view, the risk is exceptionally small at any exposure level. Miss Martin, that's the claimant's occupational hygienist, estimated levels of exposure were very low and twiddling at the edges would have no impact for present purposes. It would be irrelevant to compare them with environmental exposure, as to which Dr. Morgillen supported Professor Jones' methodology. Dr. Morgillen would regard a level of risk as insignificant if a reasonable person would not worry about it. He observed simply that by entering the court buildings he increased his risk. He would not advise Mrs. Kerr that she was under an increased risk, such as it was much lower than cooking by gas. A particular problem in Scotland, I don't know, but that was the analogy he used. And then his evidence was accepted. I'm just seeing at 68, where again Dr. Morgillen gets praise from the court for his experience. And then at 70, that's on page 73, the judge says Dr. Morgillen was able to offer rational explanations for A, the epidemiological data, for example, as to why peritoneal mesothelioma predominated in cohorts involved in large commercial exposure, and B, for the most non-existent evidence of it at low dose levels, and C, for the much higher potency of amphibolyal fibres. Fairchild exception depends upon proof of material increase in risk of harm. Dr. Morgillen persuasively explained why, in his view, at the very low levels of exposure involved here, and even if one adopted Miss Martin's upper range figure, any risk was so small that no reasonable person would have concerns accept all his evidence. So that's why it's a method 3 case, really, in this case.
Does it really add anything here? Because on method 2, you have to establish the right to rely upon Hodgson and Darnton.
Yes.
That's your first hurdle. If you overcome that, then on your case, irrespective of the figure one takes, yours or the claimant's figure, for background risk, there's no material increase.
Well, that's true, but it was really a belt and braces approach, that if your lordships were not with the respondent on method 2 and you find objection to it and that it had kind of tried to replicate Sienkiewicz, let's say, that therefore method 3 was proffered as the other alternative, which is an absolute risk analysis rather than the relative risk analysis, which is what method 2 is.
But if we're against you on method 2 because of the reliance on Hodgson and Darnton, method 3 doesn't say that.
No. Well, that's an interesting question as to whether if a clinician can give a view on causation infilled by his experience and epidemiology and anything else, whether his view could be accepted without having a state trial on Hodgson and Darnton. That's not this case, but it's nevertheless, in a lot of cases, one doesn't get into this degree of detail at all. I mean, in your average industrial disease case, a clinician turns up and says, I think it was caused by the exposure, and the court says yes or no. You don't get statisticians and epidemiologists called and everything along those lines. Very often, and in a clinical negligence case, it's very often just the doctor saying it.
Yeah, but you've got a different test,
Oh,
haven't you?
yeah. But
And that's a fairly fundamental difference.
well, because you don't really have, in clin neg, you don't really have de minimis concept.
Yeah.
So,
But you inevitably have de minimis consequences where the test is material increase. So as my lady says, I mean, this is all different because it's a different particular test on causation.
oh, my lord, absolutely. And risk itself, we submit, is an epidemiological matter, essentially, by definition. So,
I mean,
sorry.
this is a particular test specific to this very difficult exercise that has to be carried out by the courts in many tragic cases. And therefore the courts really are looking to all relevant expertise. My concern, and I'm only expressing it as a concern, is method 3 places a very significant burden on the clinician.
Well, lady, it presents a burden to him, but on the other hand, it is fortified by Hodgson and Darnton. So he's able to say that epidemiologists have looked at all the knowledge that we've got of all the cohorts where high exposure has been encountered, and they are able to model this and give a view of the broad risks at particular levels of exposure. And I can say to you as well as a clinician that I don't think materially that's medical material. So I accept it when I was floating the suggestion that do you need epidemiology, that was a bold view in these sorts of cases. But the epidemiology does bolster what the clinician would say. And as I indicated, it does mean that it's not a pure relative risk exercise. Because Sienkiewicz obviously hints at whether you should just use statistics. And I'm saying, well, you can add the medical evidence to that. But, you know, I don't think I put it any higher than that. But obviously a number of judges have accepted that as being a way forward. Similarly, then, the issue of risk in Sienkiewicz, I thought I ought to spend a little bit of time just on Sienkiewicz, if I may. So, Sienkiewicz is one or two at 21. If I may start just with because I think it's been canvassed reasonably well, that the argument of counsel for the appellants was a doubling the risk test was necessary for essentially to prove a material increase in risk, and that was rejected for obvious reasons. If one looks at that central passage of Lord Phillips, which is at 111, paragraph 111. Firstly, sorry, it's paragraph 107, I think I need to start with, I beg your ladyship's pardon, that's on page 501. where the judge says what constitutes a material increase in risk. The parties were, I think, agreed the insertion of the word material is intended to exclude an increase in risk that is so insignificant the court would probably disregard it on the de minimis principle. So obviously the word material must mean something, because otherwise the test would be increase in risk. So that's what he's positing there. And the question in our case we would submit is, how do you define and use the concept of materiality in mesothelioma cases? And then he goes on to say that Mr. Stuart Smith, as he then was, his argument of doubling the risk, establishing causation, that obviously doesn't work, because you're effectively establishing causation if you're establishing doubling the risk. So that can't be a test of de minimis, which is clearly correct. And jumping over the page then to page 111, what Lord Phillips says in that paragraph is, the reality is that in the current state of knowledge, and I do emphasise that, in the current state of knowledge, to pick up the point made by my lady yesterday, in the current state of knowledge about the disease, the only circumstance in which a court will be able to conclude that wrongful exposure of a mesothelioma victim to asbestos dust did not materially increase the victim's risk of contracting the disease will be where that exposure was insignificant compared to exposure from other sources. Now, firstly, obviously, I would stress the expression in the current state of knowledge, because there's no question about Hutchinson and Darnton or anything along the Bannister line of cases having been put before the court in this case. But the other point I would make respectfully is that, as Lady Hale reminded us, all these comments are obiter, as she says at paragraph 169, which I'll come to in a minute. In terms of once one gets outside the basis for the appeal. And also, I would submit respectfully that that as a statement of law is not correct. The idea that if exposure is material, it becomes immaterial because there's another exposure that's even more material, just can't be right. As well as the fact of being overtaken by events, this is obiter, and I would say that that's just not right, with respect to Lord Phillips. So I don't think I can really put it any higher, but it isn't right. The last three lines of that paragraph say, I note that in Rolls-Royce Industrial Power India Limited and Cox, counsel for the employer conceded that exposure to asbestos dust for a period of 1 week would not be de minimis. Just for your lordship's and ladyship's note, Cox was industrial exposure on a very heavy scale. It was a welder doing maintenance work at power stations, and he was heavily exposed according to the evidence. So no doubt to crocidolite probably and amazite. Recorder at the trial said he viewed 1 day's exposure as de minimis, but not the week of that heavy exposure. So, but again, there's no indication as to why he said.
So that was hypothetical.
Yes,
because the claimant had in fact been exposed
for a week.
Right.
But for some reason, the recorder at trial said 1 day he viewed as de minimis. But again, there's no explanation as to why that conclusion was drawn.
No.
We do say that that is qualified by the reference to current state of knowledge. And in fact, the court did caution against the overinterpretation of what is said in this case, or Baroness Hale did, at paragraph 169 on page 521. There she says, that means in cases where the Fairchild exception applies, there is no room for the more than doubles the risk approach to causation. It is not necessary in order to establish causation, and it is not an appropriate test of what is more than de minimis increase in risk. So we do not need to go into the relevance of statistical probabilities as to the finding of causation for the purposes of deciding these cases, nor in the event did the Court of Appeal need to do so. The reason why Lord Phillips of Worthwood Travers and Lord Roger have decided this subject, discussed the subject at such length, is the obiter observation of Lady Justice Smith, at paragraph 23 of a judgment in the Court of Appeal that was, because she made a reference to doubling the risk. So she concludes by saying, anything we say on the subject, therefore, is also obiter. And I would say that paragraph 111 is indeed obiter. And in any event, things have moved on since then. Just also to look then at what Lord Roger says, I think the court was taken to Lord Roger at paragraph 163 yesterday, but I do want to emphasise one point. He's on page 519.
Yeah, we were taken to 162 and 163.
And it's the second sentence of 163, where Lord Roger says, obviously, for example, epidemiology is likely to lie behind much of the evidence on which a court determines whether an exposure has materially increased the risk of the claimant developing a disease. So we would say that is a clear support for the argument that you need epidemiology to prove, not always, but very often to prove material increase in risk.
What we were taken to was later in the paragraph, where he says, I think he cautions against the use of epidemiology in relation to finding something on the balance of probabilities.
Yeah, Lord, I think that what everyone is going back to is the yellow taxi, blue taxi fallacy, which is on page 498, where Mr. Stuart Smith, as he then was, had an interesting conversation about the colour of taxis in the Herskovits decision, an American decision. And just to look at the bottom of page 498, it's paragraph 95. Brachtenbach, this is Justice Brachtenbach dissented. He warned against the danger of using statistics as a basis on which to prove proximate cause and indicated that it was necessary at the minimum to produce evidence connecting the statistics to the facts of the case. He gave an interesting illustration of a town in which there were only two cab companies, one with 3 blue cabs and the other with 1 yellow cab. If a person was knocked down by a cab whose colour had not been observed, it'd be wrong to suggest that there was a 75% chance that the victim was run down by a blue cab, and accordingly it was more probable than not that the cab that ran him down was blue, and therefore the company running the blue cabs would be responsible for negligence in the running down. And that's the blue cab, yellow cab fallacy that I would submit that Professor Norrie almost entered into with his 2/3, 1/3 problem. And that was the mischief that certainly Lord Phillips was concerned about. The other aspect of the case that he considered in some detail, clearly found it difficult, was what he called his conundrum. And the conundrum is, why in a mesothelioma claim, if one tortfeasor has 75% of the exposure and another tortfeasor has 25% of the exposure, can you not simply say, well, the 75% is much more likely than the 25% to have been causative, and therefore liability should rest on the 75%? And a lot of this case is to say you can't just use epidemiology in that way because of the nature of carcinogenesis, where it may be that the 25% has also contributed as well as the 75%. And so he answers his own conundrum. But a lot of this judgment is an examination of why does that conundrum not work. And one does wonder in mesothelioma claims if one tortfeasor had 99% exposure and someone had 1% exposure, why could it not be said that on the balance of probabilities the 99% exposure was responsible? But that is what Sienkiewicz is really dealing with, is that conundrum for now. So what I do say is that there's those extracts. There's also Lord Dyson as well. And he's at page 534. And at 218, he says, the end of paragraph 218, he says, in an individual case, epidemiology alone cannot conclusively prove causation, which obviously must be right. But he then develops that point at 221 at the bottom of page 534, when he says, it follows that I do not find it necessary to decide whether there are any circumstances in which, as a matter of English law, causation can be proved on the basis of epidemiological evidence alone. I'm unaware of any English authority in which the question of whether causation can be proved in a straightforward personal injury case on the basis of epidemiological evidence alone has been the subject of decision. Toxic torts, such as mesothelioma, give rise to particular causation problems. Now, obviously, if it was to be put, and I'm not clear whether it is being put, that Hodgson Darnton is purely epidemiology and we're just using epidemiology, then that will be another reason why method 3 is also of assistance, because you're getting a medical component to it as well. But in general, Lord Dyson is much more amenable to the use of epidemiology, particularly in toxic tools.
What does method 1 use other than epidemiology?
Well, Lord, absolutely, it uses an R value of 1, linear risk. It's a very unsophisticated form of epidemiology, but yes, it is essentially epidemiology. So, Lord, that is Lord, one point on Sienkiewicz. We did look last night at what happened at first instance, and they used a weird hybrid of method 1 and method 2 first instance to get that 18% figure. So the exposure was mixed fibers, so amazite and chrysotyl in Sienkiewicz. So they were able to set that against the background environmental risk, which was also mixed fiber. So they were comparing apples with apples, whereas our complaint obviously with method 1 is they're comparing chrysotyl with mixed fibers, so it's apples with pears. So they had that, and they used as the denominator the HEI material from 1991, which is what was in fact used for the calculation of Professor Jones for environmental exposure, which he didn't use because he didn't need it for method 2. You see, if you remember. Because the environmental exposure levels, background ones, were only used for method 1, so we had competing ones, but not for method 2. But what was the decision at trial in Sienkiewicz was before Peto came out. So they had no epidemiological evidence on background risk. And the only evidence we could determine was that the doctor, Dr. Lawrence, had indicated that he thought that 95% of all mesotheliomas were due to asbestos. And so the court said, well, the rest were going to roll together idiopathic mesothelioma and ambient mesothelioma into that 5%. And there's no real discussion of idiopathic mesothelioma. So that appears to be, it was a bit more like method 1, but that was only because they didn't have any data from Peto. And they had the same fibers to compare apples with apples. So if your lordship would like the judgment at first instance, we have got that from Liverpool County Court. That's of assistance.
That's the one in Sienkiewicz.
Sienkiewicz, yeah. It's on a Judge Main.
Yes,
yeah.
Whose heroic efforts Lord Phillips refers to.
Well, I think it was also Mr. Justice Nicola had also.
Yeah, I was going to say it was Mr. Justice Nicola in the second one.
Yes.
Yeah. Well, I think not for the moment.
Then the final case to look at is Hennigan, very briefly. That's in bundle 1 at page 257. Hennigan, the report itself starts at 253. So this is a lung cancer case involving a number of defendants, and the case itself is authority for the proposition that Fairchild applies to lung cancer cases caused by asbestos as well as to mesothelioma. And in fact, that was the position adopted by the defendants in the case, that Fairchild was the only just way to deal with this, whereas the respondents argued, oddly, were adopting the view that it should be material contribution and they shouldn't apply Fairchild. The judgment itself, I don't need to take your lordships to, perhaps sorry, I said not take your lordship to the facts, but only paragraph 1. Where Lord Dyson says the case, this is on page 255, case concerns an individual, Mr. James Hennigan, who died of lung cancer, where 2, it is common ground that the cancer was caused by exposure to asbestos fibres. 3, he was exposed to the asbestos inter alia when he was employed successively by each of the 6 defendants. 4, biological evidence cannot establish which, if any, of the exposures triggered the cell changes in his body, which led to contracting the disease. But 5, epidemiological or statistical evidence can establish by how much the exposure attributable to each defendant increased the risk that he would contract the disease. The question is, how should the law deal with the issue of causation as between claimant and each defendant in each circumstance, in these circumstances? Then Lord Dyson in paragraph 3 mentions the test that had to be used, and he says he was employed. This is the deceased. Sorry, he wasn't deceased. He was deceased. He was employed by the 6 defendants successively between 1961 and 74. There were earlier employers who had not been sued. Parties have agreed that 1, Mr. Hennigan's exposure to asbestos over the course of his working life can be quantified as 1,335 mil years. 2, the total exposure for which the 6 defendants were responsible was 46.95 mil years, i.e. 35.2% of the total exposure, the whole exposure. 3, the doses or exposures for which the defendants were responsible range from 2.5% to 10.1%. And 4, the cumulative exposure of 25 mil years is sufficient to enable an inference properly to be drawn that lung cancer in any individual case is attributable to asbestos, providing there's a minimum 10-year interval from first exposure to the onset of cancer. The 25 mil year criterion remains appropriate for exposure to mixed fibre types with a preponderance of amphiboles if exposure involved equal quantities of amphiboles and chrysotile, then cumulative exposure of 45 mils a year is probably necessary to double the risk of lung cancer. So epidemiology was all over this case in terms of the respective risks of the defendants and whether one could determine whether the cancer was caused by smoking or was caused by asbestos. And the test was that 25 mil year criterion, or 40 mils, if there was mixed fibre types. Sorry, not mixed fibre types, if there was chrysotile and amphibole. Then looking just at 2 paragraphs, my lords and lady, on page 257, the 2 stages of the causation question. Paragraph 8, it's not in dispute that the first question, the what question, is what probably caused the lung cancer. Was it asbestos, smoking, or something else? It's not in dispute that epidemiology can be deployed to answer this question, nor is it in dispute that the epidemiological evidence shows in the balance of probabilities that the deceased exposure to asbestos was the cause of lung cancer. So, again, epidemiology was deployed absolutely critically and determinedly in that case. And then over to paragraph 9. The second question, the who question, i.e. who is liable, arises in a multi-contributor case where the issue is which contributors asbestos caused the cancer. Medical science is unable to determine the issue. The question is, in this case, whether epidemiological evidence can provide the answer. And it goes on to say that it can in this case. So we rely on Hennigan simply to show that, particularly after Sienkiewicz, epidemiology is, again, widely used in an asbestos claim and was even agreed between the parties. There was no real dispute, but the epidemiology was the only way you could determine respective liability of the defendants and also whether asbestos was the cause of this particular gentleman's cancer. And you couldn't do a lung analysis or do an individual assessment. It had to be done on the basis of epidemiology. So, Lord, I've now got ground 3 and ground 5. Ground 3 I'll be very quick on. Because I'm not sure I quite understand the point of ground 3 with the greatest respect. The appellant says it's to do with fairness grounded in the House of Lords judgment in McGee. McGee is it's described by Lord Hoffman in Barker as avant le lettre Fairchild decision. I mean, it's essentially Fairchild in a more rudimentary form. What is not clear to me is it appears to be said that where you apply the broader test of causation because the claimant can't prove, as in McGee or in Fairchild, that test in McGee is therefore reapplied again when you have to look at what materiality involves to answer the question all over again and make it impossible for the defendant to rely on any uncertainty. So this is the problem I have with the submission, because I don't, with greatest respect, understand it. The decision in McGee modified the causation test, adopted a broader test. That test was materially increasing risk. You can't then say, but McGee then means that I don't have to define material, because McGee allows me to say that, because you've got this circular argument that ends up, back where it started. So I maybe haven't put that as clearly as I intended, but I don't understand how that can be said, because the test of materiality, whether in Fairchild or McGee, still remains. And there isn't a second inhibitor put on the defendants when discussing the question of materiality. Just to look at McGee then, if we may, it's tab 31. The first point to make, I don't know if you were taken to this yesterday, I don't think you were, is that the dermatitis, it was admitted, was caused at work. Obviously, our case is different because we say your mesothelioma did not develop as a result of work, but in McGee it was. And in fact, if one looks over at page 771 at E to F, your lordships will see the judgment of Lord Reed, where he says originally the defence was twofold: the denial of any such duty, and two, an argument that the disease was of a non-occupational character, i.e. idiopathic or otherwise caused. But the Lord Ordinary decided against the respondents on both these matters, and the respondents accept these findings. So the question of idiopathic cause was not before the court, because it didn't need to be, because there already had been a decision at first instance. So we're miles from our case, we say. And then he goes on to say, so the respondent's defence in the inner house and before your lordships has taken the unusual form that breach of duty is admitted, and that it's admitted that the disease is attributable to the work in which the appellant performed in the brick kiln, but that it has not been proved that a failure to carry out the admitted duty caused the onset of the disease. And then if we jump over the page to page 772 and Lord Reed's judgment at G to H, he says, I am inclined to think that the evidence points to a former view, but in a field where so little appears to be known with certainty, i.e. the cause of the dermatitis, I could not say that that is proved. If it were, then this case would be indistinguishable from Wardlaw's case. That's the case of material contribution, not increase in risk. But I think that in cases like this, we must take a broader view of causation. The medical evidence is that the fact that the man had to cycle home caked with grime and sweat added materially to the risk that this disease might develop. It does not and could not explain just why this is so, but experience shows that it is so. Plainly, that must be because what happens when the man remains unwashed can have a causative effect, though just how the cause operates is uncertain. So if then we go over the page to top page 773, he goes on, nor can I accept the distinction drawn by the Lord Ordinary between materially increasing the risk that the disease will occur and making a material contribution to its occurrence. And then finally, at the end, the last four lines of B, from a broad and practical viewpoint, I can see no substantial difference between saying what the defender did materially increase the risk of injury to the pursuer and saying that what the defender did made a material contribution to his injury. So all that Lord Reed is saying is it's clearly unfair to the plaintiff, as he then was, to have to prove something which he cannot prove, because medical science doesn't allow him to. So we're going to take a broader view on causation, as we did in Fairchild, and say material increase in risk. It doesn't say that the word material is also to be devoid of any content because of some relaxation in the rules of causation. And indeed, Sienkiewicz, I didn't take your lordships to it, but Sienkiewicz is quite clear that one doesn't devalue or relax the ordinary rules of causation other than that which is provided by Fairchild. Lord Brown's judgment is quite clear about that. So it's entirely circular, this argument that McGee means we and Fairchild means we relax the rules of causation, and then we have to relax them all over again, in fact, to make the cases undefendable by in some way disabling a defendant from arguing materiality. That, because it's not fair. That appears to be the way the argument is put. And then finally, at the top of page 773, the Lord Wilberforce says at B, my lords, I agree with the judge below to the extent that merely to show that a breach of duty increases the risk of harm is not in abstracto enough to enable the pursuer to succeed. He might in this basis still be met by successful defences. Thus, it was open to the respondents, while admitting or being unable to contest that their failure had increased the risk, to prove, if they could, as they tried to do, that the appellant's dermatitis was non-occupational. So that it's obviously those elements to defences are being preserved within the McGee principle. McGee, as I indicated, simply sets up the question of materiality, which is followed through then by Lord Phillips in Sienkiewicz and remains as the valid test. So I don't see how it can be argued that in some way McGee makes any difference to the what the claimant has to prove, which is a material increase in risk. Well, that's probably all I've got to say on McGee and ground 3. Then, finally, if I may deal with inference and ground 5.
Yeah.
So, my Lord, the first point to make is I'd like to take your lordships and your ladyships to how this inference, or the argument of the inference, came about. So, if we look at the claimant's opening, which is in the skeleton, the core bundle, the supplementary bundle at page 17. This was the skeleton argument provided before the trial started. And your lordship will recall that the regulation we're looking at is regulation 15 on the failure to keep records. Sorry, my lord. Page 17 of the supplementary bundle.
So this is effectively the opening.
Okay. Yes.
Yeah. And which is the regulation again?
So if one looks, the regulation we are concerned with is regulation 15, which is the failure to keep records. But as we'll see, what was opened by my learned friend at trial at paragraph 71 was regulation 16, which is the failure to keep health records. And you will see that the case is put in this way: regulation 16 of the 1987 regulations, I will take you to the regulation in a moment, required that every employer shall ensure a health record is kept for at least 30 years. And then at 72, the requirement to keep records was increased from 30 to 40 years by the Control of Asbestos Work Amendment Regulation 1992. And then at 73, it says health records must contain information. And then 74, had a health record been kept in compliance with the regulations, it would have provided valuable information on the work of Raymond and Elaine and the hazards they've been exposed to. D is still an active company, now running a Volvo dealership from different premises. And then he relies on Keefe at 75 and says at 76, C's evidence ought to be treated benevolently so that D does not benefit from breach of duty. So when the case was opened, it was regulation 16 that was right on. And regulation 16 not even pleaded, in fact, and there's no application to amend. So what then happened was that during the course of the trial, because the issue of air monitoring was not alleged in the opening, it was never explored in evidence. So none of the experts were asked about this, as to whether it would have helped, how it would have helped, how it would have made things easier or not made easier, and the like. And there was no exploration, for instance, of how the system of work, as it did, it was common ground, changed during the 1980s and 1990s, where asbestos started being used less. So the brakes used to be drum brakes, then they moved to disc brakes that reduced the amount of asbestos exposure considerably, and then they went to non-asbestos over the 80s and the 90s. None of that had to be canvassed, apart from in general terms, because the issue over records was not, the case was not opened on that basis. And the key, obviously, is also chronology, because the deceased was employed between 1982 and 1989. And the regulations came into force on the 1st of March 1988. So we're only talking about a year at the end of the deceased's employment here.
1st of March 1988.
88.
1988, yeah.
So we're going to talk about a year at the end. So the vast majority of her employment, the regulations went in force. But as I indicated, the system of work was changing during the 1980s. And it's likely, but it wasn't ever put, but the system of work in 1988-89 would have been different from when she started in 1982. But none of that was canvassed because the assumption was made when generating the fibre burden that it was drum brakes throughout, because that was simpler and it was made in favour of the deceased, in fact. So just to illustrate that point a little bit further, if one looks at the judgment at Core Bundle 119, it explains how things changed. Paragraph 42.
Sorry, core bundle.
Core Bundle, page 119, it's the judgment, my lord.
119, yeah.
42, he records, Mr. Steer recorded that by the 1980s, drum brakes containing asbestos has largely given way to disc brakes, though which he meant with lower asbestos dust production, to a point at which non-asbestos alternatives were in use. He worked on the basis that Mr. Russell would have encountered non-asbestos containing brakes at times, and Mr. Russell's evidence meant that he was only exposed once a week. Due to the use of an airline, Mr. Steer used 0.15 mils as his baseline, finding this was likely too high, which translated into 0.75 milliears for the material period. That's for Mr. Russell, not the deceased. The factual setting, as derived from RR's evidence, led Mr. Steer to the conclusion that EJ's dose would have been far lower than this. In seeking to quantify this, Mr. Steer's report referred to a broad approximation and notionally assuming 100th of RR's dose, then EJ would have been at 0.00575. The report repeated that Mr. Steer was not making accurate dose estimates, as this was not possible. In the joint statement, Mr. Steer clarified that for the purposes of his calculations, he'd assumed that RR worked only on asbestos-containing brakes. So they changed throughout the 1980s, but for the purposes of the assessment, one made the concession in favour of the claimant, because it wasn't seen to be material in the way the inference is now advanced, that it was always drum brakes and always asbestos. And then that's developed at 46, paragraph 46, where Mr. Steer explained that the Ferodo study was not, that's the one relied upon by Mr. Chambers, was one not without some value, but it involved only very short-term monitoring, representing a very small part of the shift. EJ's exposure profile over the 7.5 years would have been quite complex, involving periods of nil, low, and high exposure. It's not possible to calculate a realistic average daily exposure. There's insufficient information in the Ferodo study to allow extrapolation over a shift. That's Ferodo is basically just, it's a point in time, it's an activity, you can't calculate from that. The exact amount of asbestos that was in new brake and clutch linings is unknown, and this is one of the uncertain variables. However, although there's a level of uncertainty, it is possible to make a reasoned judgment about the exposure for a mechanic. This provides a magnitude of exposure, and one would not expect the true value to be 10 times higher or lower, for example. That magnitude of exposure could be calculated with reasonable confidence for different activities. This was the case for a mechanic, but EJ's exposure raised greater uncertainty because of the additional variables at play. So one can establish Russell with reasonable confidence, but EJ was more difficult. Mr. Steer rejected the suggestion that he'd only brought into his calculation uncertainties that would reduce dose, not increase it. He emphasised that the dose estimate assumes only asbestos-containing drum linings and no improvements being introduced, although these were common by the 1980s. And then finally, at 200 and, just to look at evidence next, my lords. I apologise.
Well, this is about the possible changes.
Yes, throughout the 1980s.
But all the assessments were on the worst case
Scenario.
So do we care?
Well, we care insofar as when my friend says, well, if you'd had the readings in 1989, Mr. Chambers would have been believed, or has to be believed, because we don't have the readings from
Well, we get on to that. But
Yes.
but as far as this is concerned, the judge said it might have changed, but everybody operated on the basis of, as it were, the worst case.
Yes, no, that's correct in terms of the dose, because the issue about whether you kept records or not in 1989 was not ventilated in evidence.
I follow that submission.
Yeah.
Yes. So I don't think we need to look at all the other stuff about changing practices, because the judge has referred to them, but everybody accepted that the assessments were done on the worst case.
And the evidence, even Mr. Chambers accepts that by the end of the 80s and into the 1990s, we're getting into the disc breaks and we're getting into the no asbestos period.
Yeah.
So it's totally different from what the position would have been earlier. So if I can move on from that point.
Yeah.
Now, what then happened was, so we have the opening on Regulation 16, no evidence on monitoring during the course of the trial. And it's only in closing that this issue is raised. And if one looks at Supplementary Bundle 80 to 81, it's then, for the first time, brought into the case.
Yeah.
Regulation 15, as you can see in paragraph 70, is then cited. 71, it says, just as with Regulation 16, the period is extended to 40 years, but then Regulation 16, which is not pleaded anyway, appears to be abandoned. And Regulation 15 is then run with the same sort of terminology about Keefe in paragraph 73 and saying you have to treat the evidence benevolently. So it's slotted in at this closing stage, although the inference, again, is not defined. This is one of the issues. It really wasn't defined until a friend yesterday said, well, the inference is you have to believe our expert, or prefer our expert.
Yeah, I wondered about that. I understand that submission based on these submissions, but the judge seemed to understand what the point was. If you go to 100, sorry to take you out of order, but if you go to paragraph 100 of his judgment, page 139.
That's the inference, yes.
Whilst I understand the submission made on the closing submissions, the judge appeared to think that the adverse inference point went to, as it were, redlining Mr. Steer's evidence, and that you effectively had to, I think he uses the word uncritically. Yes, the court has to adopt uncritically Mr. Chambers' calculations.
Well, Lord, it may be that actually looking at it, that is correct, that appears to be a formulation of the argument that's put yesterday. It's not, I don't think it's in the grounds of appeal or formulated, but yes.
Well, that may be. As I say, I understand the submission based on the closing, but to be fair to the judge, it appeared that he at least understood or thought that he understood where the point went, and he said no, effectively for the reasons in paragraph 100.
Lord, I can see that point.
So anyway, I understand that you were talking about the closing. Here's Regulation 15 for the first time, and nothing said about the nature of the inference the court should draw. This is Regulation 15.
So that's of the control of asbestos work regulations, which we can see if we look at A1. And tab 4. page 32 of the bundle. Just to, before we look at regulation 15 and 16, just to note, because it's material, under the interpretation, we have an action level that's defined as a certain number of millilitres per, fibres, hours per millilitre of air. That will become apparent in a minute. That's at subsection 2.1. If one then looks over to page 37, one can see regulation 15.
Yeah.
So regulation 15 says every employer shall take adequate steps to monitor the exposure of his employees to asbestos where such monitoring is appropriate for the protection of the health of those employees. The employer shall keep a suitable record of any monitoring carried out in accordance with paragraph 1 and that a record or a suitable summary thereof shall be kept. A, in the case where exposure is such that a health record is required to be kept under regulation 16 for at least 30 years. And B, in any other case for at least 5 years. And then if one looks at regulation 16, every employer shall ensure that a health record containing particulars approved by the executive relating to each of his employees who is exposed to asbestos is maintained unless the exposure of that employee does not exceed the action level. And that record or a copy thereof is kept for at least 30 years from the date of entry made in it. Now, the 30-year period was extended to 40 years from the 1st of January 1993, so that was after the deceased left. But our first submission is that regulation 16 was not pleaded, nor was any evidence called to show that the exposure of Mr. Russell exceeded the action level, because the issue of the regulations really wasn't canvassed in evidence. And so that being so, our primary submission is that the duty was only to keep the records anyway for 5 years. So she left in 1989, so they could have quite legally been disposed of by 1994. Secondly, the other very strange point about this case is that the claimant leaves in 1989. The claimant, or the appellants, are relying on not the period when she was there, but at a later period, it appears. But by the time she had left, the new regulations hadn't come in. So arguably 30 years, therefore, would have run out by the time of the trial. So they're saying, well, no, it's not. We're not relying on the exposure when she was there. We're relying on it when Mr. Russell was there. So he was there till 1994, I think, 95. So they're relying on a breach against someone who's not a party to the litigation, and over at a period when there's no duty owed to the claimant.
Mr. Russell left when?
1995. And then they're saying that in some way an inference can be drawn against the defendant in relation to the claimant over a period when she wasn't there. And again, that just kind of, as well as the nature of the inference, which is that, well, you have to believe one expert regardless of what he says rather than the other one, that itself stretches credulity, we say. But the fundamental point is that they didn't call evidence to show, they didn't plead regulation 16, they didn't call evidence to show that the action level was exceeded, and therefore they're stuck with 5 years anyway. But that argument, except wasn't put before the judge, but that appears to me to be a proper reading of the evidence. Sorry. I'm being corrected that he finished full-time employment in 95, but he did 10 years part-time employment until 2005. So we have this position where it's being suggested that there's even any evidential or probative quality to material after the deceased has left in circumstances where the system of work is changing rapidly over this period. So this is a matter of common sense, it would seem, that you couldn't infer anything even as a matter of basic judicial fact-finding because of the way in which the case is put, let alone have an entirely disqualifying argument over an inference that prevents the defendant from continuing in the case. In a sense, the inference is a matter of extraordinary potency, because it's said that, I mean, why would we bother with the trial even if you get an inference in these circumstances? What is the purpose of having the trial if, even though the judge went through the expert evidence, weighed it, decided that Mr. Steele was probably right rather than the expert for the claimant, all that is simply cast aside because of an inference over 1 year's monitoring, and we say where even the records didn't have to be kept. I mean, it's a very strange way, you'd say, in which the case is being put, and that's particularly in circumstances where we have the witness. So we have Mr. Russell. He gave evidence. He gave it on written evidence. I'll come to it in a minute. And we have experts who are cross-examined and who say, particularly in Mr. Steele, I can tell you what the rough dose was because I'm doing that from studies such as Hicklish and Plato. So then, if I can also perhaps look at the case of Keith, because that's relied upon.
Yeah.
Is your Lordship familiar? I'm sure your Lordships are familiar. With the reasons why Mr. Steele was preferred over Mr. Chambers. Do I need to take your Lordship to that? I.e. the way in which they calculated the dose?
Well, the judge explains in his judgment that he prefers Mr. Steele's calculations because they are much more consistent with the findings of fact that he made in two separate places based on his interpretation of the witness statement of Mr. Russell.
It's essentially because the study relied upon by Mr. Chambers was a study of a particular activity that he then escalated up to a whole day of exposure rather than taking peak and trough over a year, which is
yes. Well, I mean, if the judge explains that, I think, in his judgment.
He does not.
I mean, in essence, the judge was saying that the approach of Mr. Steele was more realistic, more practical.
Yes.
It's the peaks and troughs.
Yes.
Am I right in thinking that same debate would have to have taken place even with records from monitoring?
Yes, because you'd have to determine whether, well, particularly if they're only from the end of the 1980s, 1 year, how representative are they?
But even for the period you had the monitoring, to determine how you extrapolate that to a F and L year figure, you could have that experts debate.
Well, you'd have to, also because it tells you nothing, as your Lordship made clear yesterday, it tells you nothing about the exposure of the deceased.
No, I understand that.
Yeah, because she's behind a closed door in her office, and he's in a lube area 8 yards away, whatever the figure is. So absolutely, you clearly still have to have it. And we have, and this becomes clear when one looks at the decided authorities like Keefe. We have the witness there, Mr. Russell, giving evidence. We have the experts. In fact, the defendant asked the claimants for further information from Mr. Russell and was rebuffed.
Well, in fairness, it's not a question of rebuffing. Mr. Russell was not in the best of health.
Oh, no, elderly gentleman. We understood that up to a month before trial, which was when the Civil Evidence Act notice was served, that he was intending to give evidence. Your Ladyship may not have seen, there's a Part 18 request in the bundle. So I just want to take your Ladyship to very briefly. I haven't got it in my note, but it's in the evidence of the witnesses. So it's at page, just after the evidence of Mr. Russell. If one looks at page 185 in the supplementary bundle. Milady, this is a document that is clearly, it's not dated on its face, but the answers are required to be given by the 12th of October 2021. So it's clearly an October 21 document or shortly there before. And you'll see that questions were asked and replies given to question 1, for instance, is Mr. Russell still alive, able to attend trial to give evidence? And then the claimants push back on that and say Part 18 is a procedure to enable a party to clarify a matter which is in dispute or give additional information. And they conclude by saying it's an inappropriate question. The claimant can say that Mr. Russell is alive as far as the claimant is aware. And then over the page, at paragraph 3 and 4, questions are asked. If the answer to question 2A is yes, please state the make of the asbestos-containing brake shoes, whether new asbestos-containing brake shoes are referred to or a single component. Both this and the next question ask in detail information that will be useful for the experts to know. And the reply at 3 is, as you know, the deceased is dead and unable to answer your questions. The claimant was not a person exposed to asbestos and cannot answer questions 3 to 4. Mr. Russell is not a party to proceedings. The scope of Part 18 is not extended to questioning witnesses. It's a procedure for clarifying matters in dispute between the parties. It's highly inappropriate for the defendant to seek to cross-examine the witness by questions. And that is then repeated in relation to the queries at 4, where the claimants say, see the reply to question 3 above. So the same thing saying it's inappropriate. Now, this is 2021. This is 2 years before, or a year and a half, certainly before the trial, a year and 9 months. All that's being asked here is tell us a little bit more. And that was prescient, given the fact that in the end, Mr. Russell was not able to go to trial. But again, the claimants kind of made their bed on this by refusing to go to Mr. Russell and ask him at least whether he'd any view on any of those. I don't see what the objection would have been to asking him those questions. Instead, we just told it was an inappropriate question to ask. So we do say we have Mr. Russell, we have his written evidence, and that was interpreted properly by the experts. And one then contrasts that with what happened in Keefe. I just need to look at these 3 cases, and then, well, my lady, you'll be pleased that I'm done. So Keefe is in bundle 2 at tab 22. Now, just to reiterate some of the key background to the case, it's a deafness case, as my friend introduced it as, on a maritime deafness claim. You'll see if one looks at paragraph 6 that this case is, as the judge said, somewhat unusual because there's no engineering evidence of noise levels in the ships in which Mr. Keefe served during his 20-year period of employment with the defendants. There's no evidence that the defendants took any measurements of the noise levels in the ships. And the judge's finding is that they did not. They were, however, aware of noise problems, etc., etc. Then in paragraph 7, the judgment goes on. In a short judgment, the judge dismissed Mr. Keefe's claim because, as he put it, Mrs. Keefe had to prove that her late husband was exposed to periods in excess of 8 hours of noise levels over 85 dBA or fluctuating levels of an equivalent of over 85 dBA. He held that she could not prove that this was the case, even though he was satisfied that Mr. Keefe was exposed to excessive levels of noise, sometimes in excess of 90 dBA. And then, if one looks at the next jumping off point, which is paragraph 14. Your Lordship will see the findings that were made by the judge at first instance. The judge then said that holding a normal conversation at 10 feet or so was inconsistent with a noise level of 90 dB. Sorry, the judge then said that holding a normal conversation at 10 feet or so was inconsistent with a noise level of 90 dB, i.e. you couldn't hold a conversation at that level. The claimant's expert, just to interpolate there, that is the medical expert, because there's no engineering expert. The claimant's medical expert, whom the judge preferred to the defendant's expert, having said that using sign language was indicative of 90 dB plus, the judge therefore appeared to accept that if hand signals were normally used, that would be indicative of noise levels of 90 dB. Since Mr. Gunning had said that hand signals were normally used and conversations could only be carried on at coaxing voice volume, and he was not shaken in cross-examination. The judge should, in my view, have accepted in the absence of compelling contrary evidence that noise levels were at about 90 dB while Mr. Keefe was working in the galley of the ships. And that, in a sense, is entirely understandable. So they don't call expert evidence from an engineer, but they do have medical evidence that says, well, at about 90 dB, you can't hear someone, so you've got to use hand signals. And in this case, the evidence was that they did use hand signals. So even though they didn't have engineering evidence and there was no monitoring, one can infer in those circumstances that, because you had the bedrock of the evidence, that it was excessive, the noise, and the oral evidence supported the fact that that was over the course of his employment. So you can see that it's a very short leap for the judge to take and take appropriately. And then if one goes over to paragraph 19, this is a passage that has already been read to you. If it's the defendant's duty to measure noise levels in places where his employees work and he does not do so, it hardly lies in the right to assert that noise levels were not in fact excessive. In such circumstances, the court should judge a claimant's evidence benevolently and the defendant's evidence critically. So all that's being said is that the claimant's evidence is being judged benevolently because he hasn't been able to prove 90 dB because he doesn't have engineering evidence, but it's clear from the medical evidence that that is an inference that could have been drawn. So you're viewing his evidence benevolently. You're not, what my friend is asking for is not an inference. He's asking almost for a judicial predetermination or a determination of what expert should be preferred. One can see how the inference works in this case, my lords and lady, but it's totally different what is being asked for in our case. And the last three lines, he says, similarly, in paragraph 19, a defendant who has in breach of duty made it difficult or impossible for a claimant to produce relevant evidence must run the risk of adverse factual findings. Obviously here we have the man who worked in the, Mr. Russell, we have the expert evidence, we have so much more.
The man who gave evidence about the condition, the working conditions in the garage, was the claimant's witness.
Yes.
That was the only relevant witness of fact.
Yeah.
So this isn't a case where you could judge the defendant's evidence critically, the defendant's evidence of fact critically, because there wasn't any.
Well, no lay evidence, absolutely.
No, well, but it's the lay evidence that is the foundation for this, because the judge said, when looking then at the experts, he said about Mr. Chambers, it's not reflective of the factual scenario as I find it to be. So, I mean, in Keith, the defendant called the captain,
yes,
who said it wasn't that noisy, which is possibly not overly probative evidence, which was the view taken by the Court of Appeal. You can see that. And so you might look at that critically. But that does seem to be a rather different situation to this, where the only evidence of relevant fact came from Mr. Russell.
Yes, Lord. And then also, but then one also, here's all the expert evidence, and then you apply this inference to negate it all again. I mean, in a sense, it doesn't make any difference what Mr. Chambers would have said at all in these circumstances. That's why you could see how the inference slots in rather neatly in Keith, but it jars really fundamentally in this case. And the other two cases that have determined this issue since then, no inference in fact has been drawn, even though the factors may have been seen to be as strong as in Keith. First one is Shaw-Lincoln, which again we don't need to look at in great detail. It's at bundle 19 in the second bundle of authorities. Lord and Lady, it's a very different case, Shaw-Lincoln. I don't need to spend very much time on it, but it was a GP negligence claim where he didn't attend at the house of the claimant, and as a result, the claimant alleged that he suffered very serious spinal degeneration from an injury that, if he'd been taken to hospital, would not have developed in the way in which it did. So it's very different to that extent. The way in which the case was put by Mr. Burton, Queen's Counsel at that stage is in paragraph 12. And he says, on behalf of the claimant, Mr. Burton QC, appeared with Mr. Christopher Kemp, submits further that while the burden clearly lies and remains on the claimant to prove in the balance of probabilities that the breach caused the injuries suffered, the defendant, by his breach of duty, in failing to cause him to be admitted to hospital at the appropriate time, has in effect deprived the claimant of the medical records of the progress of the condition. And then he says Keefe, and he then relies on that to link with what we find in para 66, which is this is on page 47, which is where the judge records both of the experts called by the claimant, Mr. Todd and Mr. Wilson MacDonald, considered that from a medical standpoint there was insufficient evidence upon which they could properly express an opinion as to whether the claimant suffered a significant neurological deterioration in the critical period. Critical period being about 24 hours, when he should have been admitted but wasn't. So it's a very unusual case where they're saying he wasn't admitted, therefore notes weren't made following an admission that should have been made promptly. Therefore, I can draw an inference in that regard because the experts can't look at the evidence. So it's complex and difficult.
So neither of the experts offered a view. They couldn't properly express.
I think they did offer a view, and in the end, I think that the claimant failed because he had no evidence, either from expert evidence or contemporaneously, that allowed him to succeed in the argument that it would have made a difference. That's paragraph 77 to 79. But I think the facts of the case they're clearly difficult and unusual. And then there's the passage that's often quoted starting at 80.
80 to 82 is the bits that you often see.
Yeah. So essentially, where and this is cited then also in Alcoa, in Mackenzie, the Court of Appeal case. The point that's made at 81 is again to pick up on what's in Keefe. The principle really only applies where it's difficult or impossible for a claimant to adduce relevant evidence. And so that's why it was put at that high in this case, and that's much higher than we haven't got one particular piece of evidence that may or may not be of some relevance but isn't determinative. So finally then, Lord, to look at Mackenzie, that's in bundle 1 at 228. Tab 10. So again, this is another deafness case. It's a double appeal because there's a judgment in the County Court and then an appeal to Mr. Justice Garnham in the High Court, and then this case went up again to the Court of Appeal. If one looks at the issues on appeal, paragraph 3, Mr. Lim submitted that Keefe could not be applied to this case because there was, in this case, undisputed expert evidence from which the judge could find that the noise levels had not exceeded the limits of 90 dBA LAPD at the relevant time. So there was expert evidence that allowed a determination, even though there was a common law duty to keep records. And ultimately, that's what was agreed with by the Court of Appeal.
So the judge at first instance had dismissed the claim.
Yes.
It had been allowed by Mr. Justice Garnham, and the Court of Appeal reinstated the decision of the judge at first instance. Yeah.
And Mr. Theo Huckle, QC, who was appearing for the claimants at paragraph 4, he submitted, Mr. Justice Garnham was right to apply Keefe because although there was uncontested expert engineering evidence, it related to a survey of a different factory operated by a different party. So his case was, well, you didn't have records from the relevant factory, and the expert evidence was using a different factory as a comparable, and if you'd used the actual factory, it would have made a difference. So that was the way in which the case was put. Then jumping to paragraphs 15 and 16, clear when one reads these paragraphs that actually the omission of the records is a much higher status than is suggested in this case. So at 15, Mr. Worthington, who was the expert, it appears to be the joint expert, concluded, whilst it is accepted that the premises referred to are not those in which the claimant actually worked, that's when he did his comparable, the indication is that whilst there are some areas of such a mill where noise levels could exceed 90 dBA, the average level for a maintenance installation employee would be unlikely to regularly exceed such a level. Hence, without observation of contemporaneous noise survey measurements from the premises at which the claimant worked, it's not possible to demonstrate on the balance of probability that his average daily noise exposure would have reached or exceeded 90 dBA. So the expert was saying, well, if I can't say that there is an exceedance over 90 dB, and I can't say that unless contemporaneous noise evidence says to the contrary. And then at paragraph 16, he says, in answer to part 35 questions, I point out that the data referred to is of limited assistance, although if the processes and our operations were similar to those at the relevant premises, then such information would assist. Essentially, this information is what's currently available. This conclusion would have to be there's no evidence available to show what level of noise would exist. And then the key ratio is at para 50. Where the findings of fact are set out having cited from Shaw. At the bottom, it seems, therefore, it's possible to state the following propositions. Lord Justice Dingham, I think this is. First, whether it's appropriate to draw an inference, and if it's appropriate to draw an inference, the nature and extent of the inference will depend on the facts of the particular case. See Shaw linking. Secondly, silence or a failure to produce relevant documents may convert evidence on the other side into proof. But that may depend on the explanation given for the absence of a witness or a document. See Harrington. And then finally, at 54, the court sets out why it was reversing the decision of Mr. Justice Garnham, which is essentially because he had sought to overturn the findings of fact of his Honour Judge Vosper, and that in general one should be very cautious about that for all the reasons set out in paragraph 54. And I would adopt what's in paragraph 54 in relation to any temptation to overturn the findings of fact made by the trial judge in this case. But what it really stresses, I would submit this case, is that it's a matter of a fact-sensitive analysis, really relies on the discretionary exercise undertaken by the judge, and that in general this court should not interfere with that discretionary analysis, even though, as in this case, we would submit that the judge was absolutely right to resist this inference, because it is very divorced from the reality of what actually happened at the trial. And it's clearly a last-minute effort to try and create some form of hole through which to rush. So, Lords, that's all the submissions I have. The only thing was whether your Lordship would like to see the nature of the concession. That's one thing I didn't do. Made by Mr. Williams on the records, because it's in the bundle. That's where I sit down. I'll just at least show you that. It's a very measured concession. My friend puts it much wider. But, it's at supplementary bundle, page 323.
Sorry, go on.
Sorry, Lord. Page 323 at A. Now, all the concession says at A was, when obviously faced with this in closing submissions, my Lord, there is no evidence, this is at A, there's no evidence of any air monitoring being undertaken or any record generator kept. If therefore it was appropriate to do so, and again I stress if it was appropriate to do so, there would have been a breach of that duty after March 1988. Regulations came into effect in March 1988, so it would be captured the last 12 months plus of the deceased employment.
Yeah.
So that was as far as it went.
Thank you very much.
Those are my submissions.
Thank you very much.
Unless your worship's any other questions on the issue.
No, we don't. Thank you very much. Right. We'll pause there and we'll come back at 10 to 2, if that's right. I'm sorry, it's not any warmer.